Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. A couple of things real quick. First of all, we're missing our Chiron. I will fix that in just a moment. Second of all, a thank you to Grandma TCF, who during the pre-show heard me mention that bacon and eggs really sounded good, but it just wasn't going to happen this morning. So while I'm helping Beth, what gets delivered to me but bacon, eggs, and toast? So thank you, Grandma TCF. Let's get started with Judge Glazer. She is back in the saddle.
That all becomes relevant when we argue that this was self-defense, every action that he took. But ultimately, we're talking about a case where the legislators believe that a bond is appropriate. I'm asking for a reasonable bond. The state initially thought $10,000 and house arrest level 2 is appropriate. If the court wanted to increase that, again, I think that a standard bond without house arrest so that he can work and support his 7 children with one on the way in June. He's the sole supporter, and he's been in jail for 41 days. He can still work from home, but he cannot work from jail. He needs to support his family. This is a defendable case, and I'm here with a permanent appearance on this case.
Thank you. Let me hear from Mr. Cooper. He's the victim's, I guess he's the victim's attorney. Go ahead,
Yes.
sir.
Yes, Judge. Good morning. On behalf of Mr. Nantambu, Judge, this is a matter where in the allegation, it is very clear that there is a scuffle. Whoever caused the scuffle, that's irrelevant. What is relevant is that Mr. Brown then leaves, comes back with a firearm, and starts wildly shooting at my client. And by the grace of God, he was not killed. So it was Mr. Brown's intention the entire time to kill this man, to kill my client. And then he not only flees the jurisdiction to a country that he believes is non-extraditable, but he's flaunting it on social media for months. And with the help of the U.S. Marshals, was the only way that he was coming back.
Mr. Cooper.
Your Honor, if I may,
Yes.
give a rendition, please. The facts of the case are very clear. It's on video. Mr. Brown is the initial aggressor. He punches the victim in the face, and then he and his friends attack the victim. Security has to rip them all apart. The victim walks away. He walks out of the incident, and the defendant chases him down with a gun and shoots at him at point blank range. They have a history together, back and forth. There is animosity there. But at this point, he is on video attacking the victim and chasing him down and shooting at him.
Okay.
Those are the facts of the case.
That is not accurate. Let me just respond. My client left the scene to get to his car, and he feared correctly that the victim would be waiting for him. My client took his gun, not a security person's gun, by the way. The state alleges that there was a security officer who he took his gun. It was my client's own concealed weapons permit that he has, where he retrieved his own gun. He pulled it out because he thought he would encounter this man, and he did. And that man, again, showed acts of violence. My client shot twice, not at him, but shot twice so that he can continue on to get to his vehicle. That will all be argued when we have an appropriate time. But this is a defendable case, Judge, and it's bondable.
Thank you. One question. Was the victim shot? Was he actually struck by this bullet?
I don't believe so, Judge. I think he thought that he was. He had injuries from being attacked by the defendant and 2 other people. I believe at one point he thought he was. And I would say, Your Honor, that I can't speak to that, but I don't believe so.
Thank you.
Judge, I
Yes.
can play for you.
I don't need to hear that. That's not part of the record now, and that's for trial.
He does say I was scratched on my neck, not by a bullet.
Thank you. Mr. Brown, I am ordering that you stay away from the alleged victim, Zui Kwarnen Kwambe Nantambu. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim, the alleged victim, his home and school and place of employment at all times. Was this arrest location at a club or a bar?
Judge, he was in Dubai. He was
Where this
It
incident
was in
occurred.
Little Haiti in Miami.
say it a boxing event, a social media
In Miami.
boxing event.
Do you want him to stay away from this location?
We have no objection to him not
I
returning
don't
to that
know the
location.
address, but let me get the address from the warrant. Is it 221 North 67th Street? So stay away from the location of the business or boxing venue of 221 Northeast 67th Street, Miami, Florida. Do you understand the stay away order, sir?
Yes, ma'am.
Thank you. Okay. Anything else before I rule?
Yeah.
I would just say that if, again, I think a straight bond is appropriate with a stay away. They already have his passport. But if the court is inclined to go along with what the state's recommendation was, which would include house arrest, level 2, I would tell you that he'd be living at his home in Broward, 3600 East Oak Circle. He's owned that home since
Do you
2014.
have any priors?
Judge, I believe he has a withhold out of Broward, nothing extensive.
This looks like an aggravated assault with a deadly weapon, together with maybe separate battery. I don't know why it's charged with attempted second degree.
It's
murder.
overcharged, Judge. It
Judge,
is.
A judge found probable cause, so I have to rely on what the other judge
And Your
found.
Honor, if I may be heard, if Your Honor is inclined to grant a monetary bond, I would ask that Your Honor elevate it. This man was a successful NFL player, clearly has the means to flee again. And so I would ask Your
He
Honor.
has 7 children. Are they living in
They
Dubai?
went to, yes, Your Honor,
The whole
they
family's
flew
there?
to Dubai.
There-
There was a social media post. He flew them out on his birthday and they went out on a private yacht.
They'll
His
be,
children were
they'll be
there.
here,
So he could
living
be-
here.
I may
Please
finish,
don't speak
please.
over.
Judge, he has the means to flee again. So I would ask Your Honor, if you're inclined to grant a monetary bond, to please consider that and elevate it substantially.
He had a passport. He no longer has a passport. He'll be living at his home right near my office in Broward County, right near my home, and be working zealously on his
You have
case.
dinner at your home too? So
don't
you're
think-
vouching for him that he's going to return, so, you know.
I look forward to working with him zealously on this case, Judge.
So I will set a bond. I think an increased bond is warranted. I'm going to deny the state's motion for pretrial detention pending final hearing and set a bond. It will be $25,000. I'm also going to do less house. I don't even know why he needs house arrest, but I understand the state's concern. He's going to,
So
so I'll
don't put
do,
it then, Judge.
pardon me?
So don't put it. I just offered that as an alternative to, but I don't think he needs house arrest. I'd like him to be able to still continue to earn a living and support his family and be able to liberally come to my office. and
So I'm
see
going to enter house arrest level 3. So he can work. I'm not going to give him a curfew. At least he'll have the electronic monitor on, so you know he's not a flight risk. He'll know his whereabouts. Don't cut off the monitor because then you'll face additional charges. And the division judge can always readdress the house arrest component.
That's fine, Judge. Thank you.
You have a good lawyer. Listen to what he tells you. Most importantly, stay locally in Miami. If you want to travel, you're going to have to seek permission from the court. Your attorney, Mr. Eiglarz, can explain everything to you.
Judge,
Thank you,
on
Mr.
behalf of Mr.
you.
Brown and his
Thank you,
family,
Judge.
really grateful. Thank you very much.
Good day.
Thank you.
Thank you, Mr.
Ladies and gentlemen, good morning. Welcome to the Courtroom Files Live. So we very inadvertently jumped in the middle of one of the most high-profile cases in the country at the moment. The man that you're seeing on the screen is former NFL wide receiver Antonio Brown. He was accused of an attempted murder. He had allegedly fled to Dubai. He had been extradited into New York and then taken down to Miami, where yesterday he pled not guilty, and this was his bond hearing, apparently. So, cool. I wasn't planning on that, but there it was. So, welcome. Happy Wednesday to all of you. Let's continue a little bit longer with Judge Glazer.
Attorney, anybody here for Kevin Alvarez?
Your Honor,
Good morning. Thank you.
Vanessa Mensch on his behalf.
How are you?
Go on.
Do me a favor though, you gotta spell me your last name so I can.
NAS
Nasty, N-A-S-C.
CIMENTO.
Tell me your first,
Joe. Joe.
Joe. Good morning.
Just a heads up, Mr.
Is that him?
Alvarez is incompetent to proceed, but yes, that is him.
Good morning, Mr. Alvarez. You were arrested for 3 counts of aggravated battery on a law enforcement officer, aggravated fleeing and eluding a police officer. Your attorney is here, Mr. Nessa. So good morning.
Good morning.
You want to say hi to Mr. Anushi?
Good morning, Kevin.
So what's going on, please?
Judge, Mr. Alvarez, I know there's a hold on him for F-23-1169.
Mhm.
In that case, back in May of 2023, he was found incompetent to proceed. And then in December of 23, Judge Ruiz found him non-restorable. So I don't think there should be a hold for that reason. He has been arrested in the interim on a misdemeanor case, which is still open because he's incompetent to proceed, and there wasn't a hold in that case. I know bond has not been set on the current arrest. I don't really have a PC argument to make, Judge, but I see 3 counts of aggravated battery. I think the A form details 2 counts of aggravated battery, 1 count of aggravated assault, but I don't think that's going to make a difference for bond purposes, Your Honor. I would ask that the court, let me say, I don't think he could be held on the F-23 case. I think he's entitled to immediate release because he's incompetent to proceed. The state has the option to seek civil commitment if they wish to do so. These are bondable offenses. As of 3 weeks ago, the state agreed he was incompetent to proceed in the misdemeanor case. I assure the court he's still.
It may need a evaluation.
We might need to, and Judge, and I think he's entitled to release. He can't be held pending evaluations.
I'm not sure. State, let me review for probable cause. That
Sure.
comes down first. Is it an aggravated assault, aggravated battery, or just battery?
So it says that he intentionally rear-ended the victim's marked vehicle, and then that's the first time, and then he intentionally crashed the rear of the marked vehicle a second time. And then it says that he sideswiped the victim's vehicle, trying to force the victim off of the road. I don't see allegations of injuries to the officers, although it states there is approximately $5,000 worth of damage to the police vehicle.
So it's aggravated assault.
So of note, the open case is also for fleeing and eluding,
Maybe it should be
reckless driving with damage. State's requesting a no drive order, a bond plus house arrest, and to have this case reset in front of the division judge tomorrow, and any issues of competency can be addressed there on both cases.
Okay.
Judge, I would just say, I think the A form does indicate there were no injuries. I think it is correct. These are aggravated assaults.
So count 1. Why is it 3 counts? Because he shouldn't have 1.
Well, it's 2. He rammed into the car twice, and then he sideswiped the vehicle trying to run the officer off the road. That's why there's 3 counts.
But isn't it one continuous event, or is it 3 different officers?
Same way.
It's the same officer. I think we can charge per time he hit the officer's vehicle.
So count 1, 2, and 3. There's probable cause for aggravated assault on a law enforcement officer with a deadly weapon. What bond do you want me to set on those? 2,500 each count? It's a third, it would be a second-degree felony each one.
State's requesting standard again with the house arrest, the holds.
$5,000 count 1, 2,500 count 2, 25. I'm sorry. It should be 7,500 count 1. I'll split 2 counts. $7,500 bond count 1. Count 2 will be $5,000. Count 3 will be $5,000. Count 4. Aggravated fleeing and eluding after an accident or injury. That's a second-degree felony. That's $7,500. The division judge can decide if there's house arrest. I think there needs to be a hold, even though he's found incompetent. You have to readdress it tomorrow with Judge Gonzalez Marquez.
I know she was out. Do we know who's doing backup for her?
If she's not there, she has backup. Somebody has to readdress this tomorrow. So, sir, you have a good law. One other thing, no drive order. You're not allowed to drive a motor vehicle, and if you do, you'll be in violation of the court's order, and you can get rearrested and be brought back before the court and held in jail without a bond. Do you understand, sir?
I understand.
Okay. So you have a good lawyer. Listen to what Mr. Nascimento tells you. Have a nice day. Thank you.
So based upon the court only finding PC on the assault rather than the battery, the state will withdraw the motion.
Thank you.
Thanks, Judge. Have a nice day.
You too. And she can also readdress the bond amount
Absolutely.
too, and with the imposed house arrest in lieu of.
Thank
Thank you.
Judge.
Next, we have at a turn for.
It's Wednesday. It's the Courtroom Files Live. There's no better place to be, so happy to have you all here. Let's switch it up a little bit. We will stay in Florida, but go over to Wade Mercer, where he's doing first appearances.
Yes, sir. Yes, sir, Your Honor.
And Mr. Pigler to my right and your left. So I'm seeing you at the same time because your cases are essentially identical for first appearance purposes. Each of you are accused of violating the terms of your state probation or community control. And in each of your cases, the circuit judge has signed a no bond warrant. What we do in those cases at first appearances, we go ahead and arraign you if there's an affidavit filed. And the reason we do that is I want to get a lawyer appointed to represent you as soon as I can. So if you tell me you want to have an attorney appointed to represent you, that's what we're going to do today. And I will give you a chance to ask any questions in just a few minutes. Ms. Johnson, do you want an attorney appointed to represent you?
Yes.
All right. Mr. Thomas, same question.
Yes, Your Honor.
All right. And Mr. Pigler, same question.
Yes, I do.
Perfect. I'm going to appoint the Public Defender's Office of the 14th Circuit to represent each of you in this BOP proceeding. Listen to Mr. McDaniel. He's going to give you some information, and then we're going to see if you have any questions.
Your Honor, we're going to plead not guilty. Yes, to set this on December 4th arraignment docket, and I've asked them all. Mr. Green will come by and talk to them prior to that hearing.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
Okay, so Mr. Green will see you before your court date, which is December 4th. Usually he makes those jail visits the week before the court date. Ms. Johnson, do you have any questions?
No, sir.
All right, ma'am. Wish you the best. Mr. Thomas, any questions?
No, sir, Your Honor.
Wish you the best, sir. Mr. Pigler, do you have any questions?
No, sir.
Wish you the best. Hope you have a great day. Next case is Ezekiel Jenkins. Mr. Jenkins, good morning. Mr. Jenkins, you're here for failure to appear on the charge of driving while licensed suspended or revoked. Mr. Jenkins, I'm appointing the Public Defender's Office to represent you for first appearance purposes. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Jenkins, and at this point in time, we're going to enter a plea of no contest to the charge as listed. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Is there agreed upon disposition?
Time served. I'm fine with that.
3 days jail, credit for 3 days. That'll resolve his case today.
So, Mr. Jenkins, what my understanding is from the attorney is that you've got some very serious medical issues based upon that, as well as the type of charge you have. The agreement is time served. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
There'd be a civil judgment imposed for the standard statutory fine. Is that right, gentlemen?
$400.
Mr. Jenkins, did you hear that agreement?
He says he did not.
Okay, Mr. Jenkins, the agreement is that you're going to enter a plea of no contest. If that's what you decide to do, you'll be waiving your right to a trial, and I would sentence you to time served. What that means is that you'd be sentenced to 3 days in jail, but you've already done 3 days, so the case would be over. There will be a civil judgment for the fine, which is $400. Do you have any questions about that, Mr. Jenkins?
You're basically going to get you out today. All right. He said that was fine, Your Honor.
Okay, Mr. Jenkins, is that what you want to do? I need you to say where I can hear you. Is that what you want to do, Mr. Jenkins?
Speak up and say yes.
Yes.
All right, Mr. Jenkins, I'm going to accept your plea of no contest to the charge of driving while licensed, suspended or revoked knowingly. Mr. Jenkins, I'm going to judge you guilty of that offense, sentence you to 3 days in jail, give you credit for 3 days you've already served. I'm going to impose a standard fines of $400. Mr. Jenkins, that fine and court costs will be a civil judgment. You won't go to jail. You can't go to jail for not paying it, but your driver's license may be suspended, but that really doesn't matter because your driver's license has already been suspended a couple of times. So, Mr. Jenkins, you're going to be released today. Mr. Jenkins, you do not have a driver's license. You cannot drive a motor vehicle. You need to understand that because if you get caught again, it would not be your first offense. It'd be your second offense. So that is a factor. Mr. Jenkins, they're going to process you out this morning and you're going to be released. Do you have any questions? Do you have any questions?
No.
He said no.
He said no. Yeah, he said no, Your Honor.
Thank you, Corporal. Have a good day, Mr. Jenkins. We have Trina Bellamy, I think, returning today. Ms. Bellamy, good morning. Ms. Bellamy, you're here because it looks like you were first appeared, I guess, yesterday. You had a child support matter with a purge on it and a burglary with a battery. And the best I can tell from the jail's notes is the judge yesterday chose to just wait and let me deal with the bond on the burglary with the battery today. Is that correct? Is that what happened?
Yes, sir.
You didn't get a bond set on the burglary case yesterday, right?
No, sir.
Okay. Mr. Mitchell, the state there is probable cause in the complaint, ma'am. Let me see if the state or defense have any input before I set a bond. Mr. Mitchell.
Just the standard conditions of no contact.
Okay, the state has no intent to file a motion for pretrial detention in this particular case. Is that
Not
right?
at this time.
Mr. McDaniel, anything on behalf of Ms. Bellamy?
No, Your Honor.
Ms. Bellamy, I took a look at your criminal history. It looks to me like you've been to prison one time. Is that right, ma'am?
Yes, sir.
Okay. Based upon the allegations, I'm going to set you a $25,000 bond, cash or surety, ma'am. Cash or surety means you don't have to come up with all the money. You can go through a bondsman. Ms. Bellamy, you've got a condition of absolutely no contact with the alleged victim. So, ma'am, you're going to get use the phone in a few minutes. Keep in mind, you've still got that child support issue, though. But if you
I have a
postpone and
question.
resolve the child support issue, I'm just saying I'll give you a chance to ask questions. You may have already resolved the child support issue, but if you postpone and resolve the child support issue, you'll be released. But you don't need to postpone unless you can resolve the child support issue because it really doesn't do you a whole lot of good. Questions?
I'm not familiar with this talking about whatever because me and my child was the one that was alleged. We was abused. We went to the hospital. So the other party supposed to be charged, not me. Like I didn't know nothing about that. That I had got charged with this because me, my 4-year-old child, and
All right,
me,
Ms.
we
Bellamy,
went to
just
the
hang on.
hospital.
Ms. Bellamy, you've said enough.
Ms. Bellamy, I'm going to look and make sure, but I believe I'm the judge that signed the warrant, and I believe there's video evidence from the convenience store, dollar store, where this supposedly took place at. And that video evidence indicated you were the aggressor by following the person outside and
I was in the store
Miss-
first. They
I
followed
don't-
me in the
Miss-
store.
Ms. Bellamy, I told you before, this is not the place to have this discussion. I mean, all this is being recorded.
Ma'am, I'm just trying to answer your question and tell you why that you've been accused of this. I want to make sure that's the case I'm thinking of because I've signed probably 11 or 12 warrants since I got back in the last 3 days.
But
It's been a
I'm saying
busy week.
she followed me
Miss-
to the
Ms.
store.
Bellamy,
Miss
don't talk
Bellamy.
about what you've been accused of. Your attorneys told you that. I'm telling you that. This is a recorded line. Everything you say, it's not going to help you. It may actually hurt you. If you have a question about the case, I'll try to answer it, but don't talk about what the charge itself because we are
Yes,
being
sir.
recorded. Do you want to know what it accuses you of or not?
Yes, sir.
Okay, what the complaint says, Ms. Bellamy, and don't comment on this. I'm just trying to give you some information. What the complaint says, I'm almost positive this is the one I'm thinking about. The allegations are, see where it gets to the part about the video. Yeah, the officer says, while at Dollar General, I reviewed the store's surveillance footage. The video showed you standing at a register, the other person standing at another register, and that them leaving and you proceeding out the store, following them, and that corroborated her version of what happened, that she was trying to get away from the situation, that you left before even checking out and went out there and initiated the contact. That's what you're accused of. You haven't been convicted of anything. That's what you've been accused of. Is attacking someone inside that vehicle. And I think it may have been a younger person. That's the allegation against you. Okay. Obviously you've got the right to a trial and you have the right to have an attorney appointed if you can't afford one. But right now I'm just setting you a bond. If you post the bond, you'll be released. And that's where we stand. Do you have any questions?
Yes, sir. No, sir.
All right, man. Wish you the best. We do need to give her a court date for her arraignment. Mr. Jailer, Corporal, that would be when? December the 2nd, 8:30 will be your arraignment date, man. So help remind me. It's 8:30 if they're in custody, but if they're out of custody, it's the afternoon docket, Mr. Mitchell?
No. It's all arraignments in the morning. I think it's,
Pre-trials are the ones that are different.
yes.
In custody's different time.
I
now.
think they all get notices for 8:30 for arraignments.
Okay.
Am I right, Don?
So as far as first appearance.
All right, we may come back to Judge Mercer in a little bit, but let's go to Texas, say good morning to Judge Stevens, see what's going on there.
Because of prior DWI convictions, you have an interlock device in your vehicle. Who drove you today? You drive without an interlock device. You have to have an interlock device in any vehicle you drive. If somebody drives you around, great. But if I catch you without an interlock device and you're driving, your bond will be revoked and you'll sit in jail until this gets finished. You understand? And you've got, your blood alcohol was twice the legal limit, over twice. But anyway, I'm going to reset this 1 week as well, so you can get with your attorney, okay? Get a resetting. Thank you. All right, Ron Dismukes.
Ready? Please, ready to go.
Okay. Twenty-four CR 1435 is called. The state of Texas versus Ron Fuller. Is it Dismukes? Is the way Dismukes? And you were here with your attorney, Mr. Dusler, and the state's attorney is here. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in a summary?
Yes.
In summary, this indictment alleges that on or about April 13th, 2024, in Jefferson County, Texas, it is alleged you committed the state jail felony of theft of service involving a rental of a vehicle. Do you understand that you're charged with it? Yes, sir. If convicted of a state jail, you face no less than 180 days up to 2 years in a state jail and a fine up to $10,000 can be assessed. Do you understand the punishment range you are facing for this crime? An agreement has been reached where you're going to get a second chance. You'd be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length. There would be terms and conditions of probation, which are normal and customary for this type of offense, plus restitution, most importantly, is owed. This states in the amount of $2,893.74 to the complainant in this case, who represents, is it AMS?
Davis.
Avis, AVIS.
That's a V?
Yeah, the tablets are hard to write on this morning, Your Honor.
It's a poor mechanic who blames her tools.
The new one should be here in the next week.
All right, I'm gonna redo Avis so that, because it looks like an M.
Okay,
That's A,
sorry, Judge.
We're all having this trouble. When are these tablets supposed to show up into town?
Just they're here and I am programming them with our program. So that takes a couple of weeks.
Does?
So at least at the very earliest, we'll have them next week. If not, we should have them the week after next.
Is that a guarantee?
I don't guarantee anything.
So, your husband told me. Word's not on the street. This restitution, how quickly can it get paid?
I'm gonna pay off probably in the year.
How much can you pay per month?
$300.
Sir?
$300-$400.
Okay, I'm going to order 350 a month. That's going to be a condition. If you fail, make sure if something happens, call the probation office immediately so that you don't get revoked. Have you ever been in trouble before?
No, not like this.
That means yes.
I've had a ticket.
No, I'm talking about a felony conviction.
Oh, no, sorry.
Fix this. You don't want it. You get a felony conviction, you know how long they last? The rest of your life. Okay. All right. If I follow this agreement, sir, you have no right of appeal of your case. How do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily because you are guilty?
Yes.
Yes. Show you what's marked as State's Exhibit 1 that Mr. Dusler is showing you. Did you sign that document? It's up at the top? Understand it, discuss it with your attorney, or the contents all correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No
Thank you.
objections.
Without objection, it's submitted. Among other things, the state you were mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. Yes, sir. So states Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived. Yes, it is. I'm going to follow this agreement, sir, if nothing further, and find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm instead going to place you on deferred or unadjudicated probation, which means you will not be found guilty so long as you follow these terms and conditions of probation, which include, among other things, completing a theft prevention class, paying restitution to Avis Rental, and through the personnel that are listed as the victim in the indictment, you must pay $2,893.74 up $350 at least per month. Other terms and conditions of probation will be included. The probation officer is going to go over those with you. Make sure you follow those. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 2 years in state jail. And that would be a conviction that would stay you around the rest of your life. So fix it. You can fix it. You do well, I can shorten it in a third as well, which is like a little over a year. Okay. Please see the probation officer. Good luck, sir. Thank you, Don.
All right, we got Ellie in the mix now this morning. Good morning, sweetheart. She was just scratching at the door. So we'll see how it goes with her today. Let's go back to Judge Mercer.
Thank you.
I'm going to ask that you listen to Mr. McDaniel, your attorney. Your Honor, I spoke to Mr. Jimenez. He's going to plea of no contest with amended charge of simple battery, 31 days jail credit for 31 days, $722 fine. Mr. Jimenez, if you don't pay that fine, they will suspend your license. You have 30 days. You also have a bond in Washington County, which is that $10,000 bond. If you don't post that bond, you'll be transported to Washington County. Do I have any warrants out for my arrest right now? Just that one, Washington County.
Did you get that?
So, but I can bond out. I can bond out on it. Okay. Correct. Yes. Okay. So, what is the Washington County? I've not had time to look at these. What's the Washington County case? One he was on the bond on already, and if you recall, we talked about it. The bondsman come off the bond, but the bond is still there. Or he can post them. And so is there a capias or is there not? Is this the one where we had a little confusion about whether or not there was a capias and y'all contacted Washington County Corporal? I don't know if he can hear you, Mr. Goodson.
I'm not sure. We're not 100% sure, Your Honor.
Okay. Let me look at that case. Mr. Goodson has some information, so let me look at that while he's getting some information.
Come into my office, when was that, a couple of weeks ago? And there was a lot of confusion. I called the jail, they were confused. So I called the clerk's office in Washington County and spoke to a representative. And so she told me there was an order going to be signed revoking his bond, but it hadn't been signed yet, but it would be signed that morning. And that was 2.5 weeks ago. So I don't know.
It's been signed.
There's an order granting state's motion to revoke bond in Washington County case 25-262. Okay. So let's see what it does here. The clerk is to issue a capias for the rest of the defendant and the bond is revoked. So the answer to your question is no, you cannot post bond. Your bond in Washington County has been revoked. Okay. And so the next question is, sir, go ahead.
So I got to transfer?
They'll transfer you, yes. Next question is whether or not I want to accept this plea offer. So ma'am, are you the alleged victim? Okay, so give me a second to read this complaint because when someone's on bond and they get a new charge, I want to see how serious it is and what the allegations are. Allegations of throwing a dirty diaper.
I get, and
okay, that's the allegation. So, Yeah, it's not. It's basically what Mr. McDaniel said. And ma'am, you're Miss Brooke. Okay, Taylor's your last name. Miss Taylor. Miss Taylor, are you okay with this agreement? Anything else you want to be heard on this before I accept this agreement?
I can't bond him out today. I have to wait.
No, you cannot bond him out because a judge in Washington County has revoked that bond over there because probably because of the charge here.
Because of this one, yes.
So he doesn't have a bond over there anymore.
Will the no contact still be
Just a second, one at a time. Let me see if she has any more questions.
Yes, sir.
Is the no contact order done today?
Was there a no contact order in Washington County, or is that the Washington County case had nothing to do with you? Then yes, the no contact order in Jackson County goes away as long as there's no injunction. You didn't get an injunction, did you? Okay, just the no contact for when I first appeared him originally. Yeah, so the no contact condition does go away then. Correct, gentlemen?
Yes, Your Honor.
Okay. Any other questions, ma'am?
I'm not sure if y'all know, but will it be transferred today or will it be?
Unlikely. It's possible, but unlikely, usually a couple of days. I'm not saying it won't happen. I'm saying that the normal is within 2 or 3 business days, they'll be over there. Sometimes it's the same day. Even if he gets transferred today, he wouldn't come to first appearance until tomorrow. All right. So, Mr. Mitchell, is this all agreeable with the state?
It is, Your Honor. And as you already have seen, that is agreeable with the victim.
Thank you. Mr. Jimenez, is this a plea you would like to enter, sir?
Yes.
Mr. Jimenez, I'm going to accept your plea of no contest in 25-508 MM to the charge of simple battery. A judge who guilty of that offense sentenced you to 31 days in jail, give you credit for 31 days you've already served. Court costs and fines are imposed in the amount of $722. Those will be reduced to a civil judgment. So, Mr. Jimenez, our jail will notify Washington County today that you finished your sentence here, that they need to pick you up. And as I just told your fiance, that's usually within a couple of days. That's their normal pattern. And the no contact condition for the case, this case is over with because the case is over with. If there's any other no contact out there, such as an injunction, I have nothing to do with that. Mr. Jimenez, any questions?
No, sir.
All right, sir. Wish you the best. Thank you for coming, ma'am. Yes, ma'am. We have Adam Lurch next. The rest of the period stuff. I think a lot of that's yesterday's. Mr. Lurch, good morning. Mr. Lurch, you're here in case 25-497 MM, charge of 1 count of cyber stalking. Mr. Lurch, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel as your attorney.
Your Honor, I spoke to Mr. Lurch. He's going to plea of no contest to the charges listed. He'll be sentenced to 6 months in the county jail. We have 36 days jail credit, $370 fine. He will be allowed to serve this at Chrome. And I think I've already prepared the Chrome form, sent it to the clerk if the court's agreeable. Don't matter.
Mr. Mitchell, this is one where I rejected the request for a conditional release to go to Chrome, despite Calhoun County's their position. So I've not agreed to that at all, and I don't know that I will agree to it. My main question, Mr. Mitchell, is the allegations in this complaint are that he had a pending charge against the young lady, and that while he had that charge pending, he allegedly sent her text messages saying, "I'll make sure our child has no parents." So my question for the state is, have y'all interviewed the alleged victim, and is she okay with this proposed disposition?
Yes, she is okay with this.
She's okay with him going to Chrome?
Let me double check on the Chrome portion. She was agreeable to the 6 months jail. Let me see. Just as long as there is a no contact at all. I know that was for certain.
Yeah, see, I don't have much faith in that because that was already conditioned from Judge Grover's
Yes.
case. There was a condition, no contact already, and allegedly he ignored that. So,
yes,
If you let
she
me
is okay
go,
with that.
Adam, don't say a thing.
I'm just, and I may agree with this. I don't know. I want to make sure that the alleged victim has her chance to be heard. So she's okay with the 6 months in jail, and she's okay with him serving it in Chrome.
Yes, Your Honor.
Okay. And that's what the state wants to do.
Yes.
So, Mr. Lurch, did you hear that agreement?
Yes, sir.
These are always troublesome because I know the state's agreeing with it and the alleged victim's agreeing with it, but if he follows through with what he's threatened to do, then,
Understood.
I've let him out. Of course, he's got a bond, so he could post bond theoretically and get out regardless.
I advised him not to post bond a month ago because I'm trying to just get him back to Chrome. So, I mean, he can bond out if the court wants him to, but.
I don't really want him to. I just want him to stay away from her. That's what I want.
And he's in
I
a
don't-
better state of mind. Yeah, I'm talking for you, Adams. He's in a better state of mind, Your Honor, now. He was not, I clearly was not in the right state of mind then.
So here's the question I have about these. We've had 2 or 3 of these leave Chrome. This is not Mr. Lurch's case. We've had 2 or 3 of these leave Chrome. So all I can do, if we do this order extending limits of confinement, is to issue a warrant. And then when we get them picked up, they basically finish their sentence. Now, the order says they can be, an escape charge can be pursued. I've never known the state to do that. I don't know. That might be kind of a gray area, even if they could do that. What I might be more willing to do would be probation with the condition that he go to Chrome, because if he violates that and leaves Chrome, I know what I can do to him. I can give him the maximum sentence. Whereas if I do it this way, all I can do is really give him what he had already, and he would lose his gain time based upon,
I think that's
my understanding of how the jail does it.
Correct way to do it. I mean,
Mr. McDaniel?
that's always been my suggestion. That's the correct way to do it. But,
Okay.
you know, I think the way we do it's not entirely, but that is the correct way. So.
I'm fine with doing that if we.
And if he does it, then I'm fine with the Chrome fully satisfying the sentence and him terminating his probation when he successfully completes the program. I don't have a problem with that at all. I do like the idea, if he leaves the program, there's being some incentive for him to stay, in other words.
Correct.
I'm fine with that.
So, okay.
Yeah.
So what I'm going to do, Mr. Lurch, is it's going to be the same result essentially, as long as you complete the program, but listen to Mr. McDaniel, and he's going to tell you what I think I'm going to sentence you to, and let's make sure we're all on the same page and see if you have any questions. Mr. McDaniel?
Your Honor, Mr. Lurch is going to enter a plea of no contest to cyber stalking, case number 25497 MM. The understanding he'll be placed on probation for 11 months, 29 days. He'll have a $370 fine while he's on probation. He will attend Chrome. He will leave the jail and go to Chrome. While he's at Chrome, that's part of the probation. He's got to complete that entire case program, which may end up taking close to a year. If he does successfully complete everything, that will resolve all this case here. While he's in Chrome, the court would waive any monthly fees while he's at Chrome. The $370 still needs to be paid because that's going to make sure your driver's license don't get suspended. So you need to figure out a way to make that payment while you're on probation or pay off the $370. That'll resolve this case. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Okay, and there's a condition, no contact with the alleged victim.
No contact with the victim.
Absolutely no contact. And he still has that same condition for his pending case that's in Calhoun County. But I've spoke with the ASA over there. They have agreed not to revoke his conditions of release as long as he enrolls in and completes Chrome.
Mr. Lurch, let me explain a couple of things. Number one, Chrome has an inpatient portion and a follow-up outpatient portion. As Mr. McDaniel said, the whole program's about a year. I think the inpatient portion is now 9 months. Is that right, gentlemen?
Yeah.
I think so.
The inpatient portion is 9 months, and then there's outpatient portion, just like an aftercare. The other thing is, I don't have a problem giving you credit for community service towards your court costs and fines while you're there. So if you're volunteering in the community, that would satisfy your court costs and fines at the rate we use $15 an hour. So if you work the equivalent of, what would that be? It'd be, trying to do the math in my head, 20 hours?
I got to.
I'd say 370. Between 20 and 25 hours, when you get to $370 worth of credit, you would have your court costs and fines resolved. Here's the downside. The downside is if you leave the program, or if you get kicked out of the program, or if you have contact with her, there's a violation of probation, likely, certainly possibly, maybe likely. And if that happens, Mr. Lurch, you could face the maximum penalty. The maximum penalty for this charge is a year in jail. So Mr. Lurch, knowing all of that, let me first ask you, do you have any questions about that tentative agreement?
No, sir. Where do I sign?
Is that the play you want to enter, Mr. Lurch?
Yes, sir.
Hey, has he already signed a waiver of rights form? So you've already signed a waiver of rights form. Everything we've said is on record today. So the waiver of rights form is the same regardless of the plea specifics. The waiver of rights form just waives your right to a trial, your right to call and cross-examine witnesses. Mr. Lurch, I'm going to accept your plea of no contest. In case 25497 MM to the charge of cyber stalking, I'm going to withhold adjudication of guilt. I'm going to sentence you to 11 months and 29 days probation, 370 court costs and fines. No contact with the alleged victim. You will attend and successfully complete the Chrome inpatient treatment program and the outpatient follow-up or aftercare, I think maybe what they call it. The Court costs and fines may be satisfied by public service work. If you do any while you're in Chrome, I think normally they do stuff in the community. And that'll satisfy your court costs and fines at the rate of $15 an hour if you do. Mr. Lurch, lastly, if you successfully complete the whole program, inpatient and aftercare, that will satisfy your probation and you'll be allowed to terminate your probation early. So let's say you get to the 11-month part and you've done the outpatient and inpatient, you'll check in with the probation officer. You'll check in with the probation officer when you get out of the program, when you get out of the inpatient part. And what will happen then is Mr. Goodson will go ahead and send me an order to terminate your probation because you've completed the whole program total and in full. Mr. Lurch, you've got to be instructed on the terms of your probation. Mr. Goodson, how do you want to do that?
So if the jail could just ring him up this morning, Mr. McNally, do you know when he's going or?
I've already talked to him. He can go, he's already been in there and accepted. And I talked to the pastor yesterday, I think, and he can go.
So they would probably transport him today?
Yeah, they'll pick him up. I put an order in there for the Chrome. So if you want to use that same one, just make the change.
Well, that one says order extend limits of confinement.
So
if the jail could bring him up this morning, we can instruct him. One question, Judge, as far as the probation fees, normally we waive those while they're in inpatient treatment. I don't know if you're in agreement with that.
Absolutely. They need to be waived if he's in the inpatient treatment program, in my opinion. Any objection to that, Mr. Mitchell?
No, Your Honor.
So, Mr. Lurch, you'll be brought to the courthouse after first appearance. You'll get instructed by Mr. Goodson, then they'll take you back to jail, and then hopefully you'll get over to Chrome today. It's just basically right across the street from the jail. Mr. Lurch, do you have any questions?
No.
All right, sir. I wish you the best.
It's the Courtroom Files live on a Tuesday. Welcome again, friends. I'm just so happy to be back. I missed you guys for those 2 weeks, and it's nice to be back in the saddle. Let's go to Judge Simpson. I haven't seen him yet. I've actually got my eyes on 19 different courtrooms at the moment. There's a lot going on, but let's say good morning to Simpson.
Ellen Murray. Oh, okay. She's a guest of the county, Judge. So, pardon? She's a guest of the county. Wow. Yeah, she is. What's wrong, Miss Perry? What?
I've never heard that.
What? A guest of the county?
Yeah. It's an unconsensual guess.
But still, still a guest.
You don't know that.
Well.
Since she didn't hear it before, the court does call the case people versus Jacqueline Murray.
Good morning, Judge Carbondale on behalf of Miss Murray. The record?
Jacqueline Murray.
Hello.
All right. Good morning, Judge. We are here for a supplemental sentencing. Previously, we were here before the case, before the court. This was supposed to be part of a global resolution involving a 15th district shoplifting case as well. Unfortunately, at the time, we somehow all missed the fact that there was restitution as part of the plea offer in this case. So we are, there is an amended supplemental sentencing. I have gone over the report with Ms. Murray. Basically, the only thing we're adding is a restitution, $751 on and 85 cents on this case, and then $529.72 on the 15th district case ending in 25-0021.
All right. And, all right. Ms. Murray, since this is a supplemental sentencing, you have anything else you want to say?
No, Your Honor.
All right. And you don't have any objection to this?
No, Your Honor.
All right. Very good. $125 statutory fee, $751.85 restitution to Target payable through the court. That's this court, 14A. Then $529.72 restitution to Aldi for the 15th district court case. That's payable through the court. So there are two restitutions. One's payable here, the other's payable in the city of Ann Arbor.
Okay.
All right.
All right.
I'll order 365 days in jail, credit 185 days, balance suspended. I think now, Ms. Murray, you don't have to see me again.
I think I'll see you like next month.
She's got a case with Mr. Drukas on another matter. I think it's her last
You
one,
just
right?
need to stop. Okay, we'll see you next month then. I thought you were done with me. All right.
Thank you, Judge.
Court calls the case of the people versus Jennifer Gray.
Assistant Public Defender Natalie Pate with, or on behalf of, but I do not believe with Ms. Gray, Your Honor. Since the last hearing, which Your Honor did adjourn to today's date, even though she did not appear at the previous sentencing date, I have again reached out to her, left voicemails. I have not heard back, and she has not reached out to me or my office, from my understanding. Frankly, I don't have an explanation for her failure to appear, and I certainly hope she's okay, but I would be requesting an adjournment for the record.
I'm Teresa Clare on behalf of probation, Your Honor. Ms. Gray did not appear at the last hearing. This is the second time. I did request the court to adjourn the last one, given that she's not.
You did.
I did.
You did. Against my better judgment.
Yes.
And see, this is where we are. No, go ahead. I'm sorry.
But given that she is not here again today, Your Honor, I would request that the court issue a bench warrant.
Bench warrant for defendant's failure to appear. Bond will be set in the amount of $10,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Sherry Walker. Oh, boy. Here we go.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Walker in the case ending in 0938.
And yes, Your Honor, Brandon Bird on behalf of Sherry Walker in 0865. Ms. Walker, can you please take your correct?
Sherry Ann Walker. All right, very good. All right, go ahead, guys.
Thank you, Your Honor. Today's the date and time set for sentencing in both cases. As to my case, I've reviewed the report with Ms. Walker, and we do not have any changes or corrections, and we would be asking the court to adopt probation's recommendation.
And yes, Your Honor, I did get a chance to go over the pre-sentence investigation report with Ms. Walker. No additional corrections, and we do ask to stick with the recommendation of the probation department, Your Honor.
All right. Ms. Walker, anything you want to say?
I'm just glad that this took care of, and hopefully I make a difference in my future.
I believe it's going to be more than hopefully, Your Honor, because I do get a lot of time to talk with Ms. Walker. We get a lot of talk time, and she seems like she really wants to make a change in her life.
I do.
You know, I remember everything. So if you come back on, I'm going to remember.
Oh, yeah.
All right. I'm not going to blame you. I'm going to blame him. All right. Not Miss Pate. Miss Pate's having a day.
Ms. Walker wouldn't want me blamed either.
Yeah. All right. In the case ending in 0938, sentence of the court, $125 fine to court costs, 93 days in jail, credit 93 served. In the other matter, $125 state fee, 114 days in jail, credit 114 served.
Thank you.
All right. Thank you. And Ms. Walker, good luck to you in the future.
Thank you. Appreciate it.
Take
Thank
care.
you, Your Honor, and you and the Honorable Court have a great day.
That's it for you?
That's it for me, Your Honor.
Really?
Really.
People have to let me, so Mr. Allen said that you sneak into the courtroom and sit places. We can't do what Mr. Allen said we should do, and that was put a bell around your neck.
Oh,
so don't you remember the conversation? Okay. Sorry, may have been somebody. It might have been somebody else. I'm sorry. My bad.
Ellie, Barbara gave you $5. Do you want to say thank you to Aunt Barbara? There you go. Good girl. Ellie says thank you. Thank you, Barbara. I appreciate it.
Good morning. This is Assistant Public Defender on behalf of Ms. Height. Sorry. Ms. Height, state your name for the record, please.
Victoria Height.
Thank you.
Your Honor, today is the date and time set for sentencing. We did review the pre-sentence report. Do not have any material changes, additions, or deletions. We ask that you adopt the sentence recommendation.
Height, is there anything you'd like to tell the court before I impose sentence?
No, sir.
All right. Sentence of the court, 12 months probation. Fines and costs of $500, $360 probation oversight fees, $1,893.08 restitution to Walmart payable through the court. How are you intending on getting that paid, ma'am?
I can pay 400 today, and then I'd like to set up a payment plan.
Do you have the $400 in cash?
Yes.
All right. So $400, that will go toward the restitution. And in terms of a payment plan, what are you thinking?
Well, I'm in the process of getting a loan out, so I should be able to pay it in full within a month. So any payment plan is fine at this point.
I'll note that
Something
for
to
the
get me
record,
through
but
to
I'll have a
next
payment
month.
plan as arranged by probation. To get that paid. If you're gonna pay it in 30 days, I'd suggest that you do that. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to attend individual therapy with proof to probation. Complete 25 hours of community service as directed by probation. No going to any Walmart store within the state of Michigan. I'll order 365 days in jail. Credit 1, the balance is suspended.
Thank you.
No, I'm Teresa.
Oh.
When you go down to, when you go make your payment at the clerk's office.
Okay.
I think it's over a period. Court calls the case, People versus Savannah Bradley.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Bradley. Ms. Bradley, state your name for the record.
Savannah Bradley.
All right.
Your Honor, today's the date and time set for sentencing. We did review the pre-sentence report and don't have any material changes, additions, or deletions, and we ask that you adopt the sentence recommendation.
Anything you want to say before I do impose sentence?
No.
All right. On the count 1, controlled substance use, 18 months probation, $555 fines and court costs, $540 probation oversight fees. How do you think you're going to get that paid?
I'm gonna get a job. As soon as I get out.
She's been in custody
That'd be a payment plan as arranged by probation.
a month, I think, at this point.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a substance abuse assessment, comply with all treatment recommendations with status reports to probation. You're to obtain your GED with verification to probation. You're to maintain employment with proof to probation. You're to report to probation on Tuesday, November 18, 2025 at 11 a.m. That's an in-person reporting. And then you're to report to probation as directed. I will order 365 days in jail. Credit 26. The balance is suspended. On count 3, retail fraud, 18 months probation, $480 fines and court costs. That again is as paid with a payment plan through probation. You're to complete a theft class as directed by probation. You're to complete 25 hours of community service. No going to any Target store in the state of Michigan. You're to comply with all terms as set forth in count 1. I'll order 93 days in jail. Credit 26. The balance is suspended. Thank you.
Thank you.
Thank you.
See that? No. Okay. Court calls the case of the People versus Jason Holdaway.
Good morning.
Oh.
State your name for the record, sir.
Jason Holdaway.
All right, there's his camera. Okay, go ahead.
Your Honor, so we have to take time set for sentencing. We do ask that you adopt the recommendation. This incident that happened, I believe, over a year ago. Immediately after Mr. Holdaway did enroll in inpatient treatment at Don Farm, he did complete that program. He has been, I believe, sober for either 10 months is coming up or 12 months. Mr. Holdaway would have to clarify. I apologize, but he's really taken some steps to change the circumstances in his life. He's been a pleasure to work with. So again, we do ask that you adopt the recommendation.
All right. Mr. Holdaway, anything you want to tell the court before I impose sentence? You're muted, sir. Nope, not yet. There you go.
All right. I was just going to say I'll be a 1-year sobriety on December 4th. So
Congratulations. That's fantastic.
Thank you. Otherwise, no, nothing else, Your Honor.
You know, that's you kind of just sort of slough that off saying when your sobriety happens, but I'm going to tell you two things. One is the thought of you getting there after being a 0.31 is an amazing task and takes a lot of effort and something you should be real proud of, sir. And the other thing is, I remember people when they show up before me, and I don't know if you have any pictures of yourself when you first showed up, but if you took a picture of yourself when you first showed up and in looking at you now, you look so much better. Just
I've heard
physically better.
40 pounds on since I quit drinking.
There you go. All right. So a lot of good things happen.
Yeah.
Yep. Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly, the alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I will place you on probation for a 12-month period. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. When can that be paid, sir?
Can I have a 90-day plan on that?
90 days?
Please.
All right, here's what I'll do. Payment plan is arranged by probation over a period of 90 days.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment with Home of New Vision, including all aftercare, recommended aftercare with status reports to probation. You're to provide proof of victim's impact panel attendance to probation. I'll continue to SoberLink for an additional 30 days in lieu of 2 days in jail. I'll order 93 days in jail, credit 3. The balance is suspended. All right. Thank you, sir.
Thanks, sir. Have a good afternoon.
And again, congratulations to you. Upcoming.
Thank you.
All right. Take care of yourself.
Well, that's a good story. Hopefully he can continue his sobriety and continue to improve his life. Let's stay in Michigan, but we'll move down the road a little bit. We'll say good morning to Judge McNally.
Medina, 25W8402666A and B. Your name? All right, so you waived your right to a lawyer. I'm going to go ahead and give you a court date. We're going to adjourn this out. I'll give you a 4-week date. We're going to adjourn this out. I'll give you 4 weeks. That's the best I can do, though, okay?
Thank you, Your Honor.
Give me a date 4 weeks out, if you would, please, Amy.
December 10th at 9 o'clock.
At 9 a.m., okay? Okay. People can go down the hall. We'll give you a paper notice, all right?
Thank you, Your Honor.
Have a good day. Good luck. People against Ollie. Juan, Derek, Auguster, Ollie. Got to take your hat off, sir. 22B1408578. Sir, your name, please?
Juan Ali.
And his lawyer is who? John.
Miss Patillo, I'm admitting her right now.
Okay.
What is it?
Good morning, Ms. Patillo.
Good morning, Judge.
I just need you to start your video, please.
All right, is that Mr. Auguster?
Yes, your appearance.
Dion Patillo, P82378 on behalf of Mr. Auguster. Mr. Auguster, state your full name for the court if you haven't already.
Juan Derek Auguster Ali.
I believe this is part of the March 223 show cause. Failure to attend the scheduled probation visit on March 2nd of 23. Failure to register for, attend, and complete alcohol education program level 2, and failure to pay fines and costs. Balance $12.50, although I will acknowledge there was a garnishment. I'll check on that momentarily. Count 4, that he failed to enroll in monthly chemical testing as ordered on February 6th of 23, and count 5, that he failed to provide proof of completing 8 hours of community service by February 10 of 23. How is he going to proceed on these, counsel?
So, Your Honor, the failure to report he would plead guilty on, he indicated to me that he has a certificate at home for the alcohol education. And as Your Honor already stated, he had a tax intercept for $1,200, so there should only be $50.
Okay, so let's start with the alcohol education program. The charge is failure to register for, attend, and complete. I need proof he doesn't get to keep it in his drawer somewhere. So does he want a hearing on that? If he does, that's fine.
Yes, because
Okay,
some of
let's
these,
bring in Emily Tessino, John. All right, so he's going to plead to count 1. What about count 4 and 5?
I completed.
Hang on, sir. Hang on.
Yes, sir.
Let your lawyer talk right now.
Yes, sir.
You like to ignore courts. We're going to put a star on your forehead.
so Your Honor, it's count 4, the 8 hours of community service.
No, wait a minute. Hang on. This is the March 2 of 23. He's got 5 charges. Count 4 is failure to enroll in monthly chemical testing as ordered on February 6 of 23. Count 5 is failure to provide proof of completing 8 hours of community service by February 10 of 23. What's he going to do on those?
Your Honor, he would have to plead guilty with an explanation.
Is that what you want to do, sir?
I completed the 8 hours of community.
Hang on.
Yes, sir.
Your lawyer just told me you're going to plead guilty as to counts 1, 4, and 5. We're going to take up the issue of the fines and costs on count 3, and that you're telling her that you completed the alcohol education program. So we're going to have a hearing on that. If you want to have just listen. Do you want to have a hearing on counts 4 and 5, failure to enroll in monthly chemical testing as ordered on February 6 of 23? If you do, no problem.
Mr. Augusta, understand you have to provide proof to the court of everything that you completed. Do you have that proof?
I'll have to, once
Tell you what I'm going to do. I'm going to make this easy. We're going to enter a not guilty plea on all of those. And as soon as Ms. Tessino comes in, I'll take testimony, and you'll have the right to testify or remain silent if you so choose. And we will go from there. Okay, so I'm entering a not guilty plea. Did you call her, John?
Call me around. Just trying to find the file.
Because the file's old. Because the defendant doesn't like to show up. He's got other warrants out too. So we'll wait. Detective, just bear with us. I'm going to go on to another case. It should not be long.
Okay, thank you.
People Against Miracle, Rodney Dean Miracle, 25W838504, 24W834355, A and B. Come on up to the podium, sir, and tell me your name, please.
Rodney Miracle.
On October 26 of 25, the police think you operated a motor vehicle without a valid license. I also have a driveway license invalid charge. And I have 2 counts of driving while license invalid. Let me see here. April 15 of 24 and October 26 of 25. And I also have a charge of failure to pay on the improper lights rather. You posted a bond on that. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
No.
Sure?
Yep.
All right. On October 26 of 25, it is alleged that you did operate a motor vehicle without a valid license on Holner West in Woodhaven at 3:35 in the morning. That is misdemeanor punishable by up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
And you also have a charge here for the same offense from April 15 to 24. Same possible penalties. Do you understand that?
Yes.
And then you also have a charge of failure to pay $213 on the unauthorized lights on file 355B. If I find you didn't pay and your failure to pay was not without your fault, you could be held in contempt and incarcerated 1 day for every $10 owed. Do you understand that?
Yes.
All right. Did you sign an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
Do you still wish to waive your right to a lawyer?
Yes.
All right. I'm going to enter a not guilty plea on the drive-all license invalid charges. I'm going to give you a personal bond on both of those. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You do, well, on 55A, I'm continuing your $300 cash bond that was posted, it's 3,010%, that was posted by Natalia Moreno. And then you also have, and I'm entering a not guilty plea for you on the other file, the contempt charge. And I'll let you go talk to the prosecutor. So what I'm going to do is we're going to handle all three of those. If he doesn't give you what you want, you can apply for a court-appointed lawyer. And also, I want you to understand that Ms. Moreno would have to be here for us. Where is she? She a girlfriend or something?
Yeah, she's my kid's mother.
I'm sorry?
Yeah, she's my kid's mother.
All right, well, I'm going to need somebody to convey to us that they want us to apply the bond if that's the case, okay? She doesn't have to, but then we're going to proceed accordingly. So you go back and talk to the prosecutor, and either way, you will come back and inform me, okay?
Okay.
Thank you. Recalling that one, Derek Auguster Ali, 22B 140857A. All right, Ms. Tessino, your name again? Mr. Auguster, your name?
Detwan Derek Augusta Ali.
Ms. Patillo?
Deanne Patillo, P82378, on behalf of Mr. Augusta Ali.
Detective, your name, sir?
Detective Plath, Brownstone Township Police Department.
So we are dealing just because he doesn't like to show up. He doesn't.
File, I'll be honest, I didn't know what you needed it for.
Well, he's in custody from a 5-count arraignment on a probation violation, 5-count charge, I should say. That's dated March the 2nd. He was supposed to be here March 16 of 23, and he didn't show up. So I'm going to ask you to go get that file. No, Ali is the last name. Augusta Ali is the last. So I've entered a not guilty plea form. He's pleading not guilty. People against Benson, Nicholas Allen Benson, 25B1478.
Let's switch it up. We're going to go back to Judge Glazer. It's the witching hour there for her now. We're coming up on lunchtime. Let's see how she's holding up.
Check the box. Division judge may not modify the conditions of the bonds. So I'm saying there's probable cause. Count 1, grand theft of a vehicle is $30,000. Let me just see a second. Count 2, organized fraud is $30,000. Count 3, fraudulent use of personal identification is $30,000. And count 4, possession of a stolen or fictitious driver's license is $10,000. So total bond of $100,000. I don't know if the state was asking for an Ebby or the judge didn't write that down, so I'm not going to include that. Have a nice day. You can visit the division judge if you're seeking to modify your bond. It's Judge James. Next, tab to Brea Bell. Page 4. Good morning, Ms. Bell.
Your Honor, she's on probation F22.
5428 Alpha.
There's a hold. Thank you. Good morning, Ms. Bell. You were arrested for armed robbery with a firearm or deadly weapon, aggravated assault with a firearm, criminal mischief, and battery. I will appoint the public defender's office for you. Right, so there's probable cause for the charges, I guess. Is it has the gun?
Yes.
Remove the victim's gun from his pocket. Because it's a firearm, that makes it an armed robbery? Not a strong arm?
Well, there's a gun involved. It's an armed robbery.
Ma'am, you were ordered, well, do you live with the victim and do you have to go to his home? It says you don't live together, but you have to go to his home to collect any personal belongings?
Not that I know of.
Okay. Ma'am, you were ordered to stay away from Trevon Thomas, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. So you have the hold to see the division judge. I'm also going, as to count one, there is probable cause for armed robbery with a firearm. I'm going to grant the state's motion for pretrial detention pending final hearing and hold you at no bonds on count one. So the division judge can readdress that tomorrow or set a final hearing on that state's motion tomorrow. So count two, aggravated assault with a firearm is $5,000. Count three, criminal mischief, $150. There's probable cause for the M1. Count four, battery is $1,000. Have a nice day. Next, Tracy Walker, page 4. Good morning, Ms. Walker. You were arrested for burglary to an unoccupied dwelling. I will appoint the public defender's office for you.
It's a structure, not a dwelling, and based upon limited criminal history, maybe pretrial.
Okay. So the victim said that a bag of money was missing, $1,200. So, ma'am, you are ordered to stay away from the Alapada BG at 22345 Southwest 112th Avenue in Miami, Florida. You're not allowed to go to that business or store. You must stay away from there. You understand?
Yes, ma'am.
All right. Pretrial services alternate bond is $2,500. Have a nice day.
All right, she's holding up pretty well, but I think this is the first time she's worked this week, so that probably helps. Let's go Texas, back to Judge Stevens.
6867 is now called the State of Texas versus Edwin LaPaul Jones. You're Mr. Jones? So you're Edwin Jones? Yes, sir. Here. Mr. Burbank, you recognize him. He's been your attorney. I've got a motion on.
That was withdrawn.
That was.
I just was hired on in August. This has to do with a federal loan. And I think I was waiting on some stuff that I didn't communicate with the third or fourth attorney that's had this. And now it's dropped into Mr. Laird's lap. It started with Ken LaFleur, I guess way back when. Florence, not before.
I do have an extensive note that says, spoke with Burbank about the plan, and I don't know what the plan is. So
yeah, and that was another assistant district attorney. We were creating a plan.
Look, this was You know why this has my attention?
Yes, sir. Sure.
It's almost older than me.
Well, it also deals with the federal government, so.
Nonetheless, I mean, this was indicted in April it'll be 5 years next April. This has been, the crime allegedly occurred June 27th of 2020, which is 5.5 years ago.
I've only been out
hello?
for, I believe, the last 75
Well,
days, 90 days.
It was indicted though in 21. What took so long?
He lived out of
Did he
county.
move, did you move around or something?
No, he was out of county judge. He was up north of Silsbee and never knew that.
Well, I know, but somebody had to
No,
be looking for him when an indictment is just circulating around.
nobody.
Generally, the defendants don't say, "Oh, I heard the words on the street that I got an indictment. I'm coming." I mean, somebody goes, the bailiff, I'm sorry, a constable or someone like that is given the papers and they go out and do you still live at 445?
Yes, sir.
McNally, that was what was in the indictment. So.
Yeah, well, I mean, you're talking about Hardin County Palace, and
Well, okay, then why haven't there been any appearances or something?
There have been a few. But I don't think there was Mr. Burbank there. There's been a few. Been on the trial docket a couple of times.
All right, what do we do today?
I asked for a short recess judgment, 4 weeks before the holidays. So that I can get with Mr. Laird. There is information that we need in reference. It's a SBA loan.
What is is there a loss? Here it says more than 30, less than 150,000. What is the actual loss?
Well, that's what we're trying to determine, you know.
What's state say?
Good question.
Since this was Mr. Eckhart's case, it just got thrown at me.
Okay, he applied for a loan for 50,000.
Looks like the total indebtedness is 52,160 was what the total indebtedness was. I don't know if that's what the actual restitution is now, but.
Says you applied for a loan for 50,800.
Yeah, well,
So it must have been maybe interest.
Accrued interest, yes.
Where are you working?
Wooden pallet,
What do you do there?
job, shorts,
Okay, how much do you make an hour?
20.
If this proceeds and is disposed of, restitution is always required in these types of cases.
Yes, sir.
So it states that there's over $50,000 that's going to be owed. And that may or may not be correct. I don't know. If you actually received all of that or gave any of it back. That's one of the things that everybody's going to figure out, but that's a lot of money to pay back at $20 an hour. So. But. All right, so this didn't go federal. Actually.
Not surprised too.
That's what worries me when we get stuff that the federal government doesn't file. There's usually a reason.
I know. Tell me about it.
There's usually a reason.
Is 3 weeks good for you?
Yes, sir.
1:30. That's what the way it was when I was there, though. It's not the way, I mean, we jumped on everything we could. Never gave it up to this day. Never did. This is a different. No. Tierra Norman. Tierra Norman, please. Is that you?
Yes, sir.
Okay, here in this case, as you may know, you were charged with the state jail felony of theft. And anyone who has 2 or more prior convictions of thefts in a court of record, whether it's county court of law or district courts, when you steal a pack of gum, it's an automatic felony. And how many prior theft convictions do you have? Don't look at him. You're the one I'm asking. How many, ma'am? No, give me a yes.
Like.
See, I would know.
8.
9. It's 9. They're 9. So, and this is an example of what kind of you've got to realize that honesty is in your best interest. Can't even figure out in this probable cause affidavit what the amount of loss is or what was involved in it, but a penny issue, a felony. But this, there's no number here in the probable cause affidavit.
It was clothing items, Your Honor. The value was approximately $405.12. They were all recovered from dealers.
Yeah, I don't see a number here in the probable cause. It's all. So, Mr. Bergman, today, what?
I asked, we're still trying to work it out.
Is 2 weeks going to be good, you think, for this?
Which,
Sir?
the holidays.
3 weeks? 3?
I'll take 3.
Okay. Get a resetting, please.
Thank you. May I be excused?
Yes, Kiana Baker. Kiana Baker, please. Are you Tiana Baker?
Yes, sir.
And here in 25 CR61, you probably are aware you are charged with a second-degree felony of injury to a child, which carries with it no less than 2, no more than 20 years confinement in prison, or a fine or a fine up to and a fine can be assessed up to $10,000 as well. I was thinking of a cell phone, and this was indicted back in January of this year. So, what are we going to do today?
Judge, we're still trying to get to a resolution to keep the reset status. Maybe we offer today the discussion.
No. Much time, because this is like the 6th resetting we've got. Looking at the resettings, Christian, yeah. But it's not, that's not important. What do you need?
We could have 30 or 60 days.
You got it. Is 6 good? 6 weeks?
Yes, you.
Good. Okay. Anything else we need to take up now?
I think they're gonna go over the new offer and maybe they'll get it back in 2 weeks.
Okay. Get a resetting system. Yes, sir. Thank you. Deanna Baker, that was you.
Yes.
Wayne Francis has been reset. And that was three, looks like 4 cases. We'll jump to Edwin Alonzo Mayfius Salazar.
Good morning, Your Honor. No. Bless
You
you.
okay there, kid?
God bless you. Now, what you doing?
2 in the mouth, 5 on the chest. We gotta remember that if we need
That allergy.
to get to, okay. Okay. I'm caught up here. All right, 2 problems occurred here. One of them got solved when the brother did not wish to prosecute the defendant for taking his vehicle without permission. But the other problem is 85 miles per hour in a 30-mile-per-hour zone gets the attention of law enforcement and everybody else. That's highly irresponsible. And because of it, you're looking at a 3rd-degree felony, which carries with it up to 10 years in prison. So you got to deal with it responsibly. What are we going to do with that?
Your Honor, we are waiting on media that we don't have yet. So
What are we
just
doing about
for
getting that?
I informed her how we go about sharing media in this county, and
we have been in communication, Colin and I, about the case, Your Honor,
Well, that's,
prior to the court dates.
how's that working out?
there's an offer on the table at this point. He's going to get me a mitigation packet to see if that changes anything, but there is an offer that's been relayed.
It looks like you've been in this since July.
That's right.
Substituted for John West, who's public defender.
Yes, Your Honor.
So what is it we need to do to help get this together and going?
We've
things
a
forward?
few weeks.
Yes, I would.
Is 3 weeks good?
We could
You
do
said
3 to 4 weeks.
Your Honor?
Yeah.
Yes.
3 weeks gonna be okay. What do y'all, that's after, that's not a holiday. That's- All
Right
right, get
after.
it reset.
Thank you, Your Honor.
We need to take up anything else right now? Just on this? No?
I think that's it.
No. What about your driving habits? You're following the, or do you still have a driver's license? Or not? Sir? Permit. You know, you have to drive responsibly or else it has its consequences. That we all have to drive. That's, so you respect and other drivers. And it's for the safety of not only you, but others. That's what we kind of, when we're driving, we make a deal with everybody else that will be responsible because if something bad happens, it may not just be you that's involved. It may be strangers who are minding their own business and doing the right things. You don't want that on your hands, right? Okay, fix that. Try to get a reset in 3 weeks.
Thank you, Your Honor.
Barbara, thank you for the gifted membership. Very much appreciate that. I don't know what Michael was doing in my absence, but I know that I have had a commitment for this channel for months now to provide you with 9 to 11% more Judge Boyd. So let's go to San Antonio. Which, by the way, there's a road rage shooting situation going on in San Antonio as well right now.
8, State versus David Bearfield III. Could I have parties announced for the record?
Orlando Weiss for Mr. Bearfield.
And are you Mr. Bearfield? All right, Mr. Bearfield, the court previously informed you and informed your attorney that I have previously represented your uncle, Christopher.
Yes, ma'am.
Did you have a chance to discuss that with your attorney?
Yes, ma'am.
And are you waiving any conflict I may have? What I can tell you is I'm going to be fair. I don't have any conflict. All right. Okay. Defense, have you had a chance to speak with your client?
We did, Your Honor, and he had no conflict with you presiding over his case.
All right. Counsel, have you received all discovery in this case and did you review it with your client?
Yes, Your Honor.
The court will find that the state is in compliance with discovery. Cindy, do you need a cough drop or water? It's one of those days. You know how they say, I know it like the back of my hand? Well, I got a little bit lost because I looked at my hand. I'm like, I don't recognize that. See what happens when you age? All right, Mr. Bearfield, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Bearfield, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? By indictment, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You understand? You're going to need to speak up so that the court will. You need a break, Cindy? Let me know when you're ready or if you need a break. Okay. All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, counsel, and the right to remain silent, counsel?
Yes, Your Honor.
Yes,
Did you understand? Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bearfield, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, the DOEP course, MRT, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead?
Good to know, contest.
No,
No
you have a
contest.
choice, guilty,
No
not
contest.
guilty, or no contest.
I'm not used to
That's okay. So how do you plead?
no contest.
State any evidence.
No objections, Your Honor, for purposes of the plea.
Right. And state, is there a reason the request for anger management?
So
Okay.
that case was, well, I guess to stipulate the evidence that's stipulated to is turned into our office. I'm not sure why this was not generated, but when I went back to the discovery, I thought that this was part of.
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after viewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor,
Anything you wish to say on behalf of your client?
that the court follow the plea agreement that we have arranged with the state of Texas.
All right, how old are you?
32.
32. Do you have any children?
Yes, ma'am.
What are their ages?
8 and 13.
And do they live with you?
No, ma'am.
Do you have regular contact with them?
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I'm a quality inspector.
And what are you expecting?
Beverages.
I'm sorry, what?
Beverages.
Okay.
Yes, ma'am. For 5 years.
I'm sorry, what?
Been doing it for 5 years.
Okay. If you're drug tested today, what would the results be?
I'll give you negative.
Okay, why are you doing this?
I would just say I was at the wrong place at the wrong time.
No, you were not at the wrong place at the wrong time, because that pink, according to the stipulations, the pink backpack was yours.
According to stipulations.
I mean, do you want to be in prison?
No, ma'am.
And let me just tell you, the reason why I ask these questions is because you need to start thinking about what you're doing. And if you don't want to do the right thing for yourself, then do it for your children. Because I'm telling you, if you go to prison, by the time you are released, your children will not recognize your face, won't know who you are. They'll be calling someone else dad. You need to step up to the plate and start doing your job and doing better, and making the Bearfield name a good name, because you're the third. And if the second and the first before you didn't do the right thing, then you need to do something. You understand? All right, this is what the court is going to order. There's a $1,500 fine that will be probated. There's to be regular reporting by Zoom or in person, regular random UAs, Proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Do you live by yourself?
I'm out.
Who do you live with?
My grandmother.
Okay. Why? Why don't you have your own place?
It's because I've always lived there. I take care of my grandma.
How do you take care of her?
I just make sure I'm there to give her love and care.
Do you pay bills at that location?
Yes, ma'am.
Don't be a freeloader, all right?
Not
Make sure you pay the bills there and don't bring drama and chaos to your grandmother's house. What I've learned from my time as a prosecutor and defense attorney, usually people are at grandmother's house because grandmother is just, sleeping, not on top of everything that's going on in their house, and people just use her house as a hangout. Do not do that to your grandmother. You understand?
Yes, ma'am.
And they're going to be field visits at that house. So there's to be field visits 1 time per month until further notice. The MRT course, 120 hours of community service restitution. Did you graduate from school?
No, ma'am.
Why not?
Something happened at school, and I just didn't get back to complete.
All right. I'm going to order parenting classes. Once he completes parenting classes, 60 of those hours will be deemed satisfied. For the remaining hours, you can either do 60 hours, which they're going to have you outside picking up trash in the heat. They're probably not going to let you do anything while it's cold. It'll be during the heat, right? You can either do those 60 hours or either you can obtain your GED or some type of trade school certification. 5 years deferred adjudication. And anger management. Probation, is there anything else? Is there anything else you need from the court in order to be successful? I'm sorry?
Let's see. Gonna go over the misdemeanor charge.
I'm sorry, what? Okay.
No.
We do want to clarify something for the court, Your Honor. You said no unsupervised visit with minors. Does that include his children?
Until once you completed the parenting classes, then I usually lift that. And let me just tell you why in this court, normally I will give people parenting classes. The reason why I do that is because when people are picking up offenses, they're not thinking about their children. And you need to realize that your children can't take care of themselves and they're 100% dependent upon you and your support. And if you're in jail or if you're in prison, you're not able to support them. So those classes, I've actually taken a parenting class because I like to see what I'm asking people to do. Depending on which person is giving the class, those classes are very informative for you. And it's something that you can probably add to whatever you've already learned from your parents, the good things, okay?
Yes.
All right. So is there anything else you need from the court to help you be successful on this probation?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. And so what's up with the tattoos?
This it says God.
Okay.
God, and it says prolific. That's just me.
All right. I'm always interested.
Yes, ma'am.
Like, for example, did the face tattoo hurt?
Not really.
People always say that after the fact, but my understanding, when it's being done, it's painful.
It was small, so it didn't hurt.
Let's go get one.
All right. Once you start, you can't stop because otherwise you didn't spell the complete word. All right. Good luck to you in this court. In order to be successful on probation, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel they're not addressing it, you can always come to the court. Whatever you do not just stop reporting because no good can come of that, okay?
Right.
All right, good luck to you. Just remain in the courtroom and probation will go over conditions with you.
Thank you, Judge. May we be excused?
Yes.
So just glancing through the various feeds, I've got probably close to 20 up right now, and was looking at Clayton County, the hallway court. Apparently for Veterans Day yesterday, they had a do 2 crimes, get 1 free special because that hallway is stacked. So they got some stuff going on there. So I'm going to keep an eye on that. But for now, let's go to Louisiana. Let's see what the board's got going on.
Hey, good morning. We are the Committee on Parole, and we are now at Plaquemines Parish Detention Center. Today is November 12th, 2025. My name is Cheryl Renatza, serving as chair of today's parole panel. I have Mrs. Carolyn Stapleton seated to my right, and on Zoom, we have committee member Mrs. Jerry Ledoux participating. And we have Mr. Legnon. Did I pronounce that correctly?
Yes, ma'am.
Would you, sir, introduce yourself? Do tell us your name and DOC number, please.
Good morning. My name is Stephen Legnon. My DOC number is 614622.
Right. Thank you, sir. Mr. Legnon, I'm going to read some identifying information, and then I need you just to tell me if it's correct or not. I'm going to turn it over to Mrs. Stapleton because your case was assigned to her.
Yes, ma'am.
You are classified, Mr. Legnon, as suspected felon offender. You're currently serving a 7-year sentence for aggravated battery. You were sentenced in Terrebonne Parish. Your parole eligibility date was December 8th, 2025, and you have a good time date, which is June 10th of 2027. Is that information correct, sir?
Yes, ma'am.
All right. Would you answer? Let me just acknowledge you have your girlfriend, Miss Ford, is on the line with us. And she's asked to speak, and we'll call on her shortly.
Yes, ma'am.
Answer Mrs. Stapleton's questions.
Okay, good morning. Can you tell us what you did and why you think you should be getting out early?
My charge was attempted second-degree murder, and I've learned my lesson about my charge. I admit to my crime, and I need to go home and get back to work so I can take care of my kids. I have 3 children at home. Since I've been incarcerated, I've changed a lot. I learned about my mistake. I learned myself and how to deal and manage with my emotions. I actually completed Mr. Artemis McFarland's substance abuse program. I have my certificate right here. It was a year of intensive program. I'm actually in anger management at the moment, and I also will be starting college in January. And whenever I'm pursuing a business degree, and whenever I go home, I plan to continue pursuing my business degree so I can start and run my own business when I go home.
Well, it sounds like you're accomplishing a lot of good things in your life while you're in jail.
Yes, ma'am.
I mean, that's really good that you're taking advantage of all of those things.
Yes,
Now,
ma'am.
the police report, as I do it, you want me to let the girlfriend talk first?
It's up to you.
Okay. While we're on this subject, I don't know how your victim's doing, okay? Because
Yes,
what
ma'am.
I read was you ran over the victim deliberately.
Yes, ma'am.
Do you know what kind of injuries your victim suffered?
No, ma'am.
Were you required to pay any kind of restitution for medical expenses or anything?
No, ma'am.
Because you ran over him, I guarantee you there were some. So there's consequences that he's suffering that, and I don't know what he was doing with his life whenever you ran over him.
Yes,
And the way
ma'am.
I read it was the witnesses said that you sped up and ran over him. It was
Yes,
deliberate.
ma'am.
Yeah. So, and it was a jealousy issue. So you're taking anger management.
Yes, ma'am.
Okay. And substance abuse.
Yes, ma'am.
I see where there was some Suboxone in your wallet.
Yes, ma'am.
Were you trying to get off drugs at that time?
Honestly, ma'am, at that time, I was dealing with some hardship in my life, and I was going towards drugs to cope with it. And me being under the influence is one of the reasons why I lost control of my emotions and did what I did. But since I've been in Mr. Timus's class, I learned a lot of things that I wasn't aware of then that I'm aware of now, especially when it comes to, the disease of addiction and, how it can affect us and the steps we have to take to be able to overcome that and change. And since I've been incarcerated, I've been sober, I've stayed on my medication, and I plan on doing the same thing whenever I go home. And during my incarceration, I've actually learned myself, got to know myself a lot better. And I've learned to manage my emotions a lot better because you deal with a lot of different personalities and people in prison. And I figure if I could do 5 years in here and not get into it with nobody and get in any trouble, I think I'll do just fine when I go home.
Well, it sounds really good, everything that you've got to say, and it sounds very positive about your outlook also in life because you are progressing and moving forward. Has anybody introduced to you like something like the accountability letter that you can write to your victim? Now they have to choose whether or not they want to get it, things like that, because you can't have any contact with your victim, but DOC offers that. Have you thought about, that's a victim awareness.
I haven't got a chance to get into the class, and nobody's spoken to me about it since I've been here.
Well, why don't you ask about victim awareness while you're there?
I have, but the way they set things up here, you have to be a certain amount of time short to get in the classes. And I've wrote and asked and I've just taken whatever they given me. But I've been here 2 years, a little over 2 years, and I've taken everything they can give me, ma'am. I can only, do what they allow me to do.
But you're telling the truth there. That's exactly right. What about so your reentry programs and your pre-release? Has there been any conversation about that?
Yes, I've talked with them, and they don't have any openings for the class right now. They just put me in anger management whenever I told them I had my parole hearing. I showed my caseworker the paper. I said, "Hey, I got a parole hearing on the 12th." And she's like, the next day, she's like, "All right, well, come to class today."
Huh. Okay. So you tell me, without anger management, what do you think? I mean, I saw where the officer said that the man was screaming that it looked like his leg was broken. What do you think suffered as a consequence of your behavior?
Honestly, ma'am, I think that's up to God. But I mean, I've served my time for my crime, and I mean, I really do need anger management, though. To be honest with you, I do need it, and
Yeah.
I would like to finish it, whether it's in here or when I go home. I do honestly need anger management.
Okay. Well, I think you're doing good right where you're at, and I think you're on a right path to be able to move forward with your life. Let's see. So I don't have any further questions.
Yes, ma'am.
Ledoux, any questions?
I don't have any questions at this time. Thank you.
You mentioned, Mr. Legnon, you're taking your meds.
Yes, ma'am.
Is that mental health meds?
Yes, ma'am. I take Prozac.
And is that just something since you've been in jail, or is that something before?
I was actually supposed to be taking it before I came to jail, and I wasn't.
Right? Why not? Because you were self-medicating?
Because I was choosing not to take it, ma'am. I was making bad decisions not to take my medication. Honestly, if I'd have been sober and been taking my medicine, I wouldn't be in here right now to this day, man.
Right. You realize that now.
Yes, ma'am.
So how did you know the victim? Do you know his name?
I think his name was Curtis. I mean, he was intimately involved with the mother of my child.
So what set you off? Did you see any?
Jealousy. I was in a relationship with her at the time, and she was cheating on me.
All right, so whenever you get out of jail, what's your transition plan? I mean, you talked about wanting to finish your, business degree and what you mentioned your own business. What type of business would that be?
Well, actually, my girlfriend, she started a trucking business, and whenever I go home, she wants me to take over and run it for her. Me and her are gonna work together on that. We plan on settling down and getting married.
How long you been in jail?
5 years and 2 months.
All right, I don't have any other questions. I think we're ready to vote. Mrs. Stapleton?
Okay, at this time, I'm not going to, I'm going to deny your parole because, you were originally charged with attempted second-degree murder. It could have easily been that. So it was very serious what you did. You deliberately ran over this man. And also there's law enforcement opposition. And you do need to finish up the classes, like you said, your anger management class and substance abuse class. You need to be able to finish up their classes.
Mrs. Ledoux?
I'm going to concur with my colleague. Did I read on here that you have an out-of-state detainer?
Yes, ma'am.
And where is that and what's that for?
Mississippi for possession of Schedule 2.
Okay. So my vote is to deny today. I believe that you need to continue the path you're on, but you're not ready for release yet. Thank you.
Yes, ma'am.
All right, Mr. Legnon, I really liked hearing what you had to say. Sounds like you've set some goals and you're excited about your education. And so I'm really proud that you're working hard at it. My vote's going to be to deny your parole for the same reasons, because I think you're at a place where you can get some really good programs to help you be successful. And I notice you only have 90 days of good time credit. So as you complete these programs, you'll get the credit and your date will move up.
Yeah, if with all my good time, I'll get released in September next year.
Right. So let me just hear from your girlfriend, Miss Ford, before we close out. Ms. Ford, what would you like to say to us?
But I actually feel like, Steven changed. When I had first met him, he was kind of like manic, and then we stopped talking for a while. And then when we, reconnected, I did notice a huge change and whatnot. And then he started opening up about like childhood, so I kind of see like where, everything comes into play with him. But like he mentioned, I actually have 2 businesses, and I just started my trucking business, Bayou State Logistics. And I pretty much had, plans for him like whenever, he got out. So yeah.
That's great.
Yes.
Well, thanks for your support of him, and thanks for speaking to us this morning. But he's got the good plan. He's got to work it. So good luck to both of you. That concludes our business in Plaquemines. We're going to sign off. It's 10:08.
Denied. Okay, the board doing what the board does. So I'm going to go back to Judge Stevens in Jefferson County, Texas, just a little bit to the west. I do want to point out before we go there that for reasons that should be obvious as soon as you see, it is partly sunny and 77 degrees in Jefferson County, Texas at this time. So with that in mind, let's head over there.
Defendant, waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
We may, Judge.
In summary, this indictment alleges that on or about September 30th, 2024, in Jefferson County, Texas, you committed the 3rd-degree felony of unlawfully carrying a weapon in a prohibited place, namely a school. Do you understand what you're charged with here?
Yes, sir.
If convicted of a 3rd-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. There is no fine here. There would be terms and conditions of probation, which are normal and customary for this type of offense. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Are the contents all true and correct here?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection. Admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1. This is part of the record for all purposes. This is a pre-sentence report waived here.
Yes, Judge.
I will follow this agreement. Stand by. I'm going to find that you are mentally competent to enter your guilty plea. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to postpone or defer any type of finding of guilt so long as you follow the terms and conditions of probation, which the probation office will be going over with you. This will be a term of 10 years. You do well, it will be shortened to 1/3 of that. There will be the normal terms and conditions of probation for this type of offense. Plus, I believe the authorities confiscated the firearm here, and you're nodding. You when you speak, you have to speak out loud so the lady can take down.
Yes, sir.
It's part of this agreement, and part of the probation order is you will forfeit that handgun to the authorities. Do you understand?
Yes, sir.
You will also be ordered to take all actions necessary to accomplish that. If you have to sign documents, you must do that. So that vehicle, that firearm can be forfeited properly. And also you will complete what's called a moral reclamation therapy. It's one of these programs that's very good on helping you make choices when you're uncertain about which is the correct choice to make. And that's always a good thing. And that's the probationers feel like they are in better control of their decision making after they take and pass that program. So you'll begin probation and speak with the probation officer. Thank you.
I personally can't believe that he allowed that in his courtroom. I mean, he's usually calling out people for how they're dressed, and it's not as bad as the world's best farter shirt that we saw a few months back in Judge West's court across the hall, but still. I just drove through this state a few days ago, in part, nowhere near Reno, but let's go to Nevada. Reno, Judge Shelley O'Neill. It's always an interesting cast of characters there. Let's see what's up.
I'm sorry, I didn't hear you.
Good morning.
Thank you. Mr. Jack, your case number is 25 CR 16553. On November the 6th, 2025, sir, you were given a citation for trespassing. Did you understand that charge, sir?
Yes, ma'am.
And how do you wish to proceed?
Plead guilty.
All right, and you understand if you enter a plea of guilty or no contest, you're giving up your trial rights here today?
Yeah.
You have to speak up a little louder.
Yes, ma'am.
Thank you, sir. You understand that the maximum penalty for trespass, as with any misdemeanor in the state of Nevada, could be up to 6 months in jail and or a $1,000 fine?
Yes, ma'am.
And sir, have you served in the United States military?
Yes, ma'am.
You're a veteran of what branch of the service, sir?
I'm leaving.
All right, sir. Are you signed up for benefits through the VA?
No.
And is there a reason that you're not signed up for benefits?
No.
Have you tried to sign up for benefits at the VA?
Not really.
Are you an honorably discharged veteran?
I do so.
Okay. All right. Well, you know that if you are unhoused or you need assistance, there are a number of people there working at the VA who can assist you to find housing and get yourself enrolled in different programs. They're available to you free of charge. Do you understand that?
Yes, ma'am.
All right, sir. I'll accept your plea as freely, voluntarily, and knowingly entered. City's recommendation is to sentencing for Mr. Jack.
Your Honor, the city has no objection to time served in this matter.
Thank you. Thank you. Mr. McGinnis?
He's been in custody for 6 days, Your Honor. He's homeless. He says he lives at the shelter. I'm hoping that we can convince him to go take advantage of the benefits that he deserves, and I'll submit it.
Thank you. Mr. Jack, is there anything you'd like to tell me before I impose a sentence, sir?
No, no. No.
Where were you trespassed from?
There's a Walmart on 155 Demonte Street.
All right. So, Mr. Jack, you know, if you've been trespassed from a building or a company, that they have the legal ability to keep you out of there for a period of up to 3 years. So you're not, I'm going to order that you stay away from that Walmart, because if you go back in, they'll probably arrest you and bring you back to jail. Do you understand, sir?
Yes.
All right. And I'm going to direct that you go over on Kerman Street downtown. Actually, in Midtown, there is a VA hospital there. And if you've not been there, you can go in, you can walk right in and sign up for benefits the same day. Do you understand that?
Okay.
All right, sir, I'm going to go ahead and I'm going to sentence you to time served. I'm going to wish you good luck, okay? Leandra Engel?
Your Honor, she was here and spoke to Mr. McGinnis. And I believe he was going to talk about maybe an eval.
Yeah, that's correct, Deputy. I apologize. I was turning to that page. It appears she had an incompetency evaluation about a year ago. Speaking with her today, it appears that it needs to be renewed.
Okay. We'll go ahead and order a competency evaluation for Miss Engel. In the meantime, there'll be a no bail hold placed on her so she can get that accomplished, hopefully sooner than later. The next matter is Ramon Martinez. Mr. Martinez, if you would come forward.
Your Honor, he was removed from the courtroom.
Okay. All right. Then Jonas McClellan.
Good morning.
Good morning, Mr. McClellan. Looks like you are here in case 25 TR 08077, which is a traffic case. And it looks like basically that you were arrested on an outstanding warrant for failing to comply with the court order. I'm going to read you that warrant so you'll understand why you were arrested. Just give me a moment to open up the warrant. All right, and it looks like
I know what it's about.
You do? Okay, thank you, because I'm having a difficult time. I have a warrant checklist, but I don't have that warrant. Here we go. Let's try this. October the 6th, it looks like there's a warrant issued here. There are a number of documents in your file, so thank you for your patience. All right, I have the warrant up, Mr. McClellan, and it was for you were before the court on operator proof of insurance, driver's license required, and a failure to appear. The warrant was signed by Judge Christopher Hazlett Stevens on October the 6th, 2025, and it reads as follows. On September the 18th, 2025, Judge Hazlett Stevens ordered you to report to the clerk's office upon release from jail to set up proof or pay conditions for insurance and driver's license. Jail records indicate that you were released on September 21st, 2025, and failed to report to the Reno Municipal Court. Did you ever report as you were ordered to do, sir?
No, I was trying to he had instructed me to get insurance on myself so that I could and he would knock the fine down. My life got kind of really hard at that time and it slipped my mind. I thought I had a little more time. And honestly, I didn't know what to do. So I apologize for that.
But you can always, here's the deal. There are 4 of us judges at the Reno Municipal Court, and you can always go in and ask for more time. You can ask for clarification. You can convert any fine to community service. We're willing to work with you, but when you just blow off a judge's order, you end up back in jail as you have.
Yes, ma'am.
So do you admit, sir, that you are in contempt of court for failing to follow the judge's order?
Yes, ma'am.
And do you understand, sir, that the contempt of court draws a maximum penalty of up to 25 days in jail and a fine up to $500?
Hold on, sit up.
Yes, ma'am. I was
All right, hold on. I got a couple more questions.
Yes,
Did you understand your constitutional rights?
yes, ma'am.
And have you served in the military, sir?
No, ma'am.
The court will accept your admission to the failure to comply with the court's order as freely, voluntarily, and knowingly entered. So is there any reason why you can't follow through with the judge's orders now?
No, I can follow through. I have a place to live and I have a job as well.
All right. What I'm going to do then, Mr. McClellan, is give you, I'm going to give you 45 days. That's to December the 29th, 2025, to go in. Well, I'm going to order immediately upon your release to go in and sign your proof or pay agreement immediately. And that means as soon as you walk out the door, and if it's after 5, you go the next day. You know where the Reno Municipal Court is?
Not the exact address, but I know how to look it up.
All right. So let me just tell you, it's very easy. 1 South Sierra.
Okay.
It's the courthouse directly south of the river, across the river from where the movie theaters used to be.
Okay.
So it's a brand new, relatively new courthouse. You go in there, you turn to the left, that's the Reno Municipal Court, and you go sign your agreement. That's the step number 1. And then I'm going to give you 45 days to get a driver's license and show proof that you have operator's policy of insurance, or you're on a family member's insurance policy. That will reduce your fine from $748 down to $200. If you don't do it this time, you're going to owe the whole $748. You understand? And then there's a $200 fee for the driver's license. So you'll be looking at about $1,000 as opposed to nickels and dimes. Do you understand that you need to kind of wake up and smell the roses?
Yes, I do.
All right, sir. That's going to be my order. When were you arrested on this outstanding warrant?
Would have been Sunday.
Okay, and today is Wednesday, so that looks like it's 4 days in the Washoe County Jail. Do you need 25 days to understand that the court order is very important?
No, ma'am.
All right, then I'll go ahead and send you the time served. I'll give you a break here today, Mr. McClellan. Please don't let me down. The next time I see you, it will be 25 days in jail. Do you understand, sir?
I do, ma'am.
All right, that'll be my order. Please go to the Reno Municipal Court and sign your agreement.
Thank you.
You're welcome. Chris Robinson.
Good morning.
Good morning. Hold on, your case is, let me find it. Your case number is 25 CR 16642. I'll tell you what that is in just a moment. My computer's opening your file now. And it looks like you were charged with simple battery on November the 9th, 2025. Did you understand the charge?
Yes.
And is it your intention to enter a plea of not guilty and schedule the matter for trial?
No, I want to plead no contest.
All right. And is that what you've encouraged your client to do, Mr. McGinnis?
I didn't encourage her. I explained to her what the facts were and what she was faced with. She has a relatively high NPRA score, 10, so she would have to bond out likely. She just wants to enter no contest plea and resolve it today.
All right. And is that correct, Ms. Robinson, what you want to do here today?
Yes.
All right. And you understand that if you enter a plea of no contest, the court will find you guilty of the simple battery?
Yes.
And did you understand your constitutional rights?
Yes.
You understand by entering a plea of guilty or no contest, you're giving up your right to have a trial in this matter?
Yes.
All right. And you understand that the maximum penalty could be up to 6 months in jail and or a $1,000 fine?
Yes.
And have you served in the military?
No.
The court will accept your plea, Ms. Robinson, as freely, voluntarily, and knowingly entered. What we typically have to do, and I'm going to wait for the city attorney to make the request, but typically if they request the opportunity to contact the victim and have the victim present at sentencing, I'm required by law to allow them a reasonable period of time to get that victim or witness. Do you understand?
Yes. Can I say something before we proceed?
Hold on a minute. Let me ask the city, and then I'll give you the opportunity to speak, Ms. Robinson. Michelle, are you seeking additional time to contact a victim?
Yes, Your Honor, the city would be requesting until Wednesday.
That's a week from today.
I would ask that the city consider tomorrow, Your Honor.
Wait a second. Tomorrow, I don't know if that would, oh, you're right. You're right. It's just my days are off because of the holiday. So it could be.
All right, so we'll go ahead and continue the matter until tomorrow. Ms. Robinson, you wanted to say something? I'm happy to hear it now.
I just wanted to say that I did work. I do work, and I'm not a threat to the community. This is just a misunderstanding. I thought I was helping a lady in an alley who was screaming for help, and I went to the alley to help and got in a scuffle and got battery charges put on me.
Okay, so and I'll consider all of that tomorrow. So the city attorney is going to reach out to this person that you're alleged to have, or you've pled no contest to battering, and we will hear from all the facts tomorrow. Then I'll make a decision. Obviously, I will listen to anything you have to say. Okay.
Yes.
All right. So we'll hold you until tomorrow. There'll be a no bail hold on you until tomorrow for sentencing. Okay.
Yes.
All right. You're excused.
And Your Honor, just real quick, I do believe that we have a phone number, so I think tomorrow will work.
All right. Thank you, Ms. Ayala. I appreciate your efforts.
All right, let's switch it up a little. We'll head back to Louisiana and give them another try.
Beckley?
Good morning. How are you?
Good. Thanks for asking. How are you?
I'm good. Great.
Well, would you introduce yourself to the panel? Tell us your name, DOC number.
Okay, Jonathan Beckley, DOC number 426869.
Right, and let's see. Let me just read some identifying information into the record,
Yes,
Mr. You're classified as a fifth. That's fifth felony
Yes,
of currently serving a 29-year sentence. You were sentenced. Well, your sentencing date, I'll say, is July 16, 2020. Possession of a firearm by a convicted felon, possession with intent to distribute methamphetamines, and aggravated obstruction of the highway.
Yes, ma'am.
So your parole eligibility date is passed. It was January 14, 2025. And you do have a good time date, mandatory release date, December 12th of 2026. Is that right?
Yes, ma'am. Yes, ma'am. Correct.
So before we get started on our interview, is there the officer still in there with you?
Yes, ma'am. Oh, well.
I can get her.
in this meeting.
I just would like to know what any of y'all could tell us about Mr. Beckley before we start our interview.
Oh, the warden and the chief of police is gonna speak for me,
Okay, good.
but
Warden?
I'm waiting on them. Yes, ma'am. Here's the DOC coordinator here.
All right, well, go ahead, sir. Introduce yourself and tell us what you think about Mr. Beckley. Tell us how he's doing.
Good morning. My name is Christopher Johnson. I'm the DOC Transition Specialist here at Riverbend. Mr. Beckley has been doing a good job here at Riverbend for the past 2 years that I've been here. I know of him being a trustee and been doing extremely well with communication with the warden, because I'm always seeing him talking to the warden. I'm always seeing Mr. Beckley helping out with anyone around the facility. He has completed several of the CTRP classes as well, and he's always been a willing participant in the classes. He makes sure that everyone is in class and they're doing their assignments, and everyone's participating, and everyone pretty much looks up to Mr. Beckley in the class because of the fact that he does participate, and he's always extremely knowledgeable about the subject material that we're discussing.
Well, that's good to hear. Thank you.
Yeah, he's definitely a good guy.
All right. Well,
May I ask a question?
Sure.
May I ask a question, sir? Has he taken his pre-release?
No, he's not taking a pre-release class yet.
Okay, so he also signed a form June of 2025 saying he refused to take that class. He said, reason refused, I have taken all classes. Particular program or service refused. He says all. That's was a part of our file. So he actually refused to take pre-release.
No, he's not refused to take pre-release. He refused to be transferred to a different facility at that time.
Well, that's not what this says.
Because with his participation with the staff here, he's always involved in doing a lot of maintenance work and additional items around this facility.
Mr. Natsa, do you see the page I'm referring to?
Yes, I do, and I understand what the transition specialist is saying. So you do offer pre-release there?
Yes, ma'am. 50-hour pre-release class.
Okay, and he has not taken it?
Correct.
Okay, that's all I need. Thank you.
He has not taken it just yet, but usually I get that class done. It takes him about 2 weeks to get that class done. I spend a lot of time with the guys before they're discharged.
Good. Well, thank you. We appreciate it. Anybody else there that wants to speak on his behalf, Mr. Beckley?
I'll get the ward.
Thank you.
Boy.
Good morning.
Morning, how you doing?
Good. How are you this morning?
I'm fine.
So for the record, sir, would you just introduce yourself and then tell us what you'd like us to know about Mr. Beckley?
Yes, I'm the warden at Riverbend Detention Center. Mr. Beckley, since his stay here, he been a real good trustee, never been in trouble here, been very helpful to the facility. And I think that if y'all give him an opportunity to go home, I think he'll be a great upstanding citizen for this community, and he's just a well-rounded, great guy. And I think that through his stay here, just became a better person. I talk to him kind of often, and I'm a pastor on the streets also out there, and so I put the word in him also.
Good. So he's been there for 4 years?
Yes.
Has he ever had any write-ups?
No.
All right. Well, good. Well, we appreciate you taking time to come speak with us today.
Yes.
Thank you, sir.
Miss Bill.
So now we got the chief.
Yes, ma'am. The chief of police.
Good morning, chief.
Good morning. How are y'all today?
Good, thank you. Tell us what you want to tell us about Mr. Beckley.
Well, JB, as we call him here, he's been working out here in our maintenance shop with the lady out there that does all of supplies and everything else. He's been out there for, I don't know, 4 years.
Yes, sir.
About 4 years. He's been a model guy, feel upstanding. And I mean, I've had no problem with JB whatsoever. He's a good guy, being around the last 4 years. So,
Well, thanks. Yes, sir. Well, we sure appreciate you coming in and talking to us. That means
yes,
a lot.
ma'am.
Appreciate it.
I appreciate y'all and whatever y'all can do for my man. Hopefully you can help him out. He's I'm ready to get him out of my hair.
I don't know how you're gonna run your warehouse.
Well, I don't know. That's the thing, is we're gonna miss him out there for sure. That's the whole thing. So, but thank y'all. I appreciate y'all's time.
Yes, sir. Thank you.
Yes, ma'am.
All right, Mr. Beckley, excuse me.
Yes, ma'am.
So what happened to you? I say that because you've a fifth offender, you've been in and out of jail, and suddenly in the last 4 years, you're okay.
Yes, ma'am.
Wow.
I understand, trust me. Miss Cheryl, I lost my mind out there. I grew up in a great family. Nobody done drugs. I was great. My mom died, and I kind of lost it. You know what I mean? I kind of lost it. But I reflect on everything I did, and I thought about all, it eats me up inside, all the people I think about, families that I messed up with drugs, and you know what I mean? It just eats me up inside. And I know it ain't right, because I took all the classes, and I think about it every day, and I pray, and that ain't what I want. I'm tired of jail. I don't want to come back to jail. I want to be a productive citizen, a productive person in society. I'm sick of this. Warden Hedgeman and the staff here, they mentor me every day, and I took that and I mentor all the guys in here. I'm just tired of it, Miss Cheryl. I'm just tired of jail. I know one thing: if I get paroled, you'll never see me again here. I promise you that.
Well, but you've had probation or supervision, good time supervision before, and you've been revoked more than once.
Yes, ma'am. I understand that. I know, but I promise you. I understand if you deny me. I understand. I'm not mad at you. You know what I mean? I'm not. No hard feelings.
You're not.
There ain't no hard feelings.
Right.
Because I understand.
Let me ask you. Hold on. Let me ask you. What would be your plan? Obviously, when you got out before, you would go back to the same places and do the same thing. So what's different now? Where would you go?
Well, I own rental property, and I'm gonna keep all my houses rented out, and I secured a house here. And when I get out, this is where I'm gonna stay. I'm staying here in this parish.
Where is your rental property?
In Caldwell Parish.
Who's managing that for you?
I actually kind of manage it myself, but over the phone. But I got a guy that's renting one of my houses, and he's the one that takes care of everything. I just cut the rent down a little. Yes, ma'am.
How long you had that? You've always had that.
I've had that since my mom died, 2016. I inherited it. Yes, ma'am.
Okay. Well, we do have a letter of support in the record from the sheriff. He's really pleased with your work at the warehouse. So I see you do have risk management. I guess the substance abuse 1 and 2.
Yes, ma'am.
Anger management, parenting, thinking for change, because you have 400 and some odd days of good time credits. But you never did, you completed the 11th grade. Do you have your GED?
No, ma'am, I never got it.
Have you ever tried?
I tried one time and I failed. I think it was math or something. It's been a long time ago. Yes, ma'am. It's been a while.
Do they have that there? Do they have that
Oh, yes.
opportunity? Right?
Yes, ma'am, but it takes so long. I work all the time, Miss Cheryl. I mean, I understand. I work all the time. I work a lot. And I know that's no
I
excuse.
say
No,
that.
no excuse.
So you've had any job skills training formally?
Not here, no, ma'am.
Yeah.
I'm a certified welder.
Okay.
That's what I did for a living. Yes, ma'am.
Okay. So you were a drug dealer or user or both?
I sold drugs to support my habit, but I
So
never
you
sold
don't-
no. I never sold no big drugs.
Well, it doesn't matter.
I mean, it doesn't matter a little bit or a lot. Yes, ma'am. I understand, Miss Cheryl. I understand. Trust me, I understand.
So why do you think you're gonna be successful this time as opposed to having failed so many times before?
Miss Cheryl, because I'm sick of it. I'm not the man I was then. I know what I got to do. I got to stay away from everybody that I used to know. Everybody. That's the reason I'm gonna move here. I don't want no part of nobody that I used to know, but my children.
Where are they?
I got one in Tennessee, one in Caldwell, and one in Winsboro.
Well, the Caldwell officials believe that you're a menace to their area and you're a career thief and a drug dealer. You apparently created havoc in that community.
Yes, ma'am. I ain't never stole nothing.
Well, you never stole anything?
No, ma'am.
Let's see. Maybe I messed up that. Let's see. Illegal possession of stolen things?
Yes, ma'am. Somebody sold me a stole four-wheeler.
Well, felony theft in LaSalle in 2009. Caldwell, theft over $500. Well, that was dismissed. So that's probably illegal possession. Here's another illegal possession of stolen things in 2018.
I think that was the four-wheeler. That's the same one. That's the four-wheeler.
So tell us what you did to get in jail this time.
Well,
Summarize for us.
Okay. Well, my mom passed away and she had a bunch of guns in the house. And the police came, the guns was there. I knew the guns was there. I shouldn't have had the guns in there, even though they registered to her, even though they was her guns. It was wrong to have the guns. And I knew better. I knew better. But I mean, it's no saying that, you know what I mean? It's just, I knew better. You know what I mean? I knew
Yep.
better. I'm a country boy. I've been around guns all my life, hunting and fishing. But I surely know now that I can't have no gun or in no house with no gun or any of that. So,
What about obstruction of highway? What was that?
well, I didn't stop for the police and they stripped my truck. So that was destruction of highway commerce.
Yeah, you put a lot of people in danger for that.
Yes, ma'am. And I understand that. I put people in danger all my life, Miss Cheryl, just doing dumb stuff. And you know, all I can say is I apologize to everybody, and I'll never do that again.
How you gonna stay away from all that? How you gonna stay sober? You said you have your own drug issues. I know you took the risk management class, but
Yes, ma'am.
when you get
First
out
thing
there, I know they're everywhere in prison too, but you'd be exposed to it everywhere.
Yes, ma'am. Yes, ma'am. I have a great support system, Miss Cheryl. The warden lives right down the road from here. I'm gonna go to his church. He's gonna kind of supervise me. The chief of police here also. I made some great friends here. And I know if I stay here and stay under them, I'll be just fine. Actually, they'll come whoop my butt if I do mess up.
All right. Where's your family today? Did you know you were coming to see us today? Obviously, because you arranged for all these folks to come talk to us.
Yes, ma'am. I even had a paralegal and a pastor that was supposed to be on my be here. I just talked to him, but they never give him the code to log in.
Well, sorry to hear that.
Yes, ma'am.
All right. Well,
And
I'm
the
just.
only family,
Go
the only
ahead.
family I have left is my children. Everybody else passed away.
Yeah. All right. Well, that's all the questions I have. Ms. Ledoux, any questions?
Well, I'm still concerned that we do have the issue of not having pre-release or GED, and those are mandatory. So,
Ms. Stapleton?
And myself personally, I know you sound like a good old boy and you're getting along with everybody there great and everybody's your buddy and friend. But I'm gonna tell you what, the things you've done are significant as far as criminal history. And possession with intent to distribute methamphetamines, stuff like that. What about the victims that that caused? And you know, that high-speed chase, who could you have hurt then? I mean, you say you did dumb and stupid things, but you're not a little boy. You're not 16-year-olds doing it.
I'm not.
So, and you've had time and time again chances.
Yes, ma'am. I understand. I
So-
completely understand.
I'm the type of person I wouldn't want to put my name next to something like this. So I'm just going to tell you up front. I think 4 years out of 29, after all you've done, I don't trust my name being next to this.
I did 8 years off of 29, man.
All right, well, 8.
Yeah,
8 out of 29. Okay. But a lot of criminal history. Severe.
Yes, ma'am. I understand.
Excessive. Okay.
I understand.
All right. So I don't see any other questions, Mr. Beckley. I'm gonna go ahead and vote first. I agree with what everybody here has said. I do believe that you are a certified welder, so you do have the job skills training. So I think you meet the educational requirements. Unless you have the pre-release training behind you, and I don't know if they do that there, do they?
You do pre-release? Yes, ma'am. Yeah.
I put a lot of stock into what the warden and the chief has said, and along with the letter from the sheriff's office. They know you. They've been with you for 4 years. The fact that your reentry plan, you recognize you can't go back to Caldwell. You need to, and you've made arrangements to change your people, places, and things. I think with their help, I think you'll be successful. So I'm going to give you a chance and release you a little early. You get out next year anyway.
Yes, ma'am.
After you do complete that pre-release program.
Mm-hmm.
And then you would have to submit to regular random drug screens and then have a curfew every night unless you're at charge or at work from 9 p.m. to 6 a.m. and then whatever conditions your parole officer would put on you. But I'm just one vote. It requires a unanimous vote. So
yes, ma'am.
I would give that chance.
Yes, ma'am.
Ms. Ledoux.
Mr. Blackley,
Yes, ma'am.
I believe people change. I'm not sure I'm hearing the kind of verbiage I would like to hear to show that you've changed. But as Ms. Renatza says, there are other people who are speaking on your behalf that are around you. You do have to have the pre-release. So I will concur with my colleague, and you must take the pre-release prior to being paroled. And that's my vote, is to condition a release upon completion of pre-release.
Yes, ma'am. Thank you.
Mrs. Stapleton.
Okay, Mr. Beckley, I like the conditions that Ms. Renasa just spoke about. I know that the pre-release is important with Ms. Ledoux. And you know, you've had some significant people put their good name next to you.
Yes, ma'am.
But once again, you'd be letting down not only yourself, but a lot of other people. You know,
Yes,
if
ma'am.
you didn't follow the instructions here. So today I'm going to defer and concur with my colleagues and concur with their conditions to approve.
Thank you so much.
So you still got a little work to do. You got to do the pre-release program. And I'm going to add, because of you know, I know you got the rental property in Caldwell Parish, but for the duration of your sentence until you're off paper, I don't want you going back to Caldwell Parish.
I'm not, Miss Cheryl, I promise.
I've come to see you.
Yes, ma'am.
All right. Well, don't let us
Okay.
down.
I'm not, Miss Cheryl, I promise. Thank you so much.
Look.
Okay, can I ask one question before we go? So what do I do when after I finish this pre-release? How does that work?
You don't worry about that.
Yeah, you don't have to worry about that. We monitor that. They let us know when you're done, and then they'll process our paperwork for release.
Okay, thank y'all so much. I won't let y'all down.
You make your parole officer your best friend.
Yes, ma'am.
All right, good luck.
Thank you.
Approved?
Well, that was interesting. He was an interesting character too. You know, I don't know if you guys noticed, but he was like definitely that country boy drawl. But then every now and then he would begin to sound like Farmer Fran from The Water Boy. His like Cajun or something would kick in and it'd become just unintelligible. But that was fun. Speaking of fun, let's go to Miami-Dade because Judge Glazer has worked through lunch. Let's see how this is working out for everybody.
Presence. Bond is $2,500.
That was Salinas, you said?
Yes.
Okay. Your Honor, the presence was waived on Mr. Salinas? Yes. Thank you.
Page 18, Damian Gomez.
Your Honor, these are
Mesana Nachang, what?
added. These are added charges. He refused court. Will waive his presence.
Appoint the public defender's office, waive presence to grand theft, burglary and grand theft. I don't know if the value's right. Let's see. I'm not sure if it's there's no value, Steve.
Right, so it would be
Car?
motor vehicle.
It's F3. All right, so appoint the public defender's office, waive presence, and you said refusal?
Yes, Your Honor.
So $2,500 count one and $2,500 count two. You have somebody on Zoom. Who is that?
Judge, this is Mr. Herbert Banks.
Thank you. Hi, Mr. Banks. Good afternoon, sir. You were arrested for damaging the fire prevention system at the jail. I will appoint the public defender's office for you. It's actually a Dade Correction Institute at the prison. You're accused of damaging the fire prevention system there.
Mr. Banks, please do not make any statements about what happened.
There's probable cause for the charge. Your bond is $2,500. Have a nice day.
Thank you, Judge.
Thank you. Good day.
So he's in custody, accused of damaging the fire suppression system at the prison. And I get paperwork and stuff, but they give him a bond, so what? He can get out of the prison that he's already in? Those are just such bizarre situations. Anyways, back to Judge.
For driving with a suspended license, third or subsequent conviction, I will appoint the public defender's office for you.
Spanish, please.
Gareth, señor, buenas tardes. Lo acusan lo arrestaron por conducir con licencia suspendida, su tercero subsiguiente condena. Voy a nombrar a los abogados de oficio.
There's probable cause for the charge. State, do you have an objection to a program? You came in on a bench warrant.
Hay motivo fundado para el cargo. Los
Although he
fiscales.
has an open case for F25-17555, shouldn't there be a hold?
Yes.
Tiene un caso abierto, F25-17555. ¿No deberíamos de detenerlo? ¿Orden de retención? Sí.
I'll set your bond at $1,500 and hold for the division judge for F25-17555.
Fianza aquí, 1,500. Voy a ordenar que lo detengan hasta que vea el juez del caso F25.
Should be a misdemeanor DWLS. There's no prior convictions indicated.
Debe de ser un delito menor, no hay condenas
Okay,
anteriores.
thank you. Probable cause for DWLS, unless you want to show me his printout.
I looked at the printout. I'm not sure if he's got the prior convictions.
DWLS, the bond will be, what do you want, 150?
500 is good.
Es un,
bond. Have a nice day.
es un delito menor, conducir con la licencia suspendida. $500 es la fianza, señor.
Next is Richard Grant, page 19. Do we have anybody else here or no? Maybe.
We have one person left, Mr. Gutierrez.
Okay.
8.
Omar Gutierrez, page 7. Good afternoon, sir. Do you speak English?
Yeah, good, Your Honor. Good afternoon, Your Honor.
Sir, you were arrested for driving under the influence of alcohol or drugs, fourth or subsequent offense. Sir, can you afford to hire a private lawyer?
I can afford to hire a private lawyer. I hire a public defender.
Do you own your home?
No, I live with my mom.
Okay, I will appoint the public defender's office for you. You're out on felony bond. There is a hold for case F25-15870. So, which is the open DWLS. So it looks like he's driving, causing damage to people or property. And also doesn't have a license.
I'm gonna try and screen share. It didn't work last week.
Your Honor, he has a total bond of $2,150 on his traffic cases.
Wonder why we're having problems with the screen sharing. We had problems yet last week a little. I can't see anything, Miss Ed. What are you showing?
I'm trying to show you his traffic printout.
If you can't find it, we're just gonna reset it for the office.
I can print it out and submit it with the afternoon paperwork or share it.
Yeah.
Yeah.
We'll reset it in the afternoon to establish that he has 3 prior DUIs convictions. So right before me now is just the DUI and also driving as a habitual traffic offender. So I'll reset it for the afternoon. All right, is there anybody else there? Corrections. Pardon me?
No, we don't have any.
So Madam Interpreter, you're free to leave. I can't see us starting any sooner than 2:15.
Okay, Judge.
Okay.
Well, other than some tech glitches, she seems to be holding up better than I thought she would. Let's, just about to wrap up the day, but let's finish it with Judge Boyd.
I think my system has frozen. Curses. Just give me one moment. I'll get back to it. That's okay. And what page was Longoria on?
Longoria?
Mhm.
Longoria, so Anthony, 3.
Yes, all right, thank you. Let me find Smith. There we are. All right, the court is calling 2025 CR 0022103, State versus Jeffrey Patrick Smith. Can I have parties announced?
Tilden Schaefer for Mr. Smith, Your Honor. Kurt Grancy, co-counsel with Tilden Schaefer.
All right, counsel, have you received all discovery and did you review it with your client?
We have and we did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smith, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it? It happens. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You're not.
Any objections?
No, Your Honor.
Did you review the court admonishments with your attorneys? Did you understand it and sign it in all the appropriate places? Did you understand in count 1, you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. Range of punishment. Just 1 second. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine. State is proceeding on count 1 only. There's an affirmative finding of deadly weapon. There's no application for community supervision. You don't qualify for community supervision legally. There is an application for deferred adjudication, and the state is recommending deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None ruled on, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with the complainant, MRT, anger management, driver safety and gun safety courses, forfeit the weapon, and understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, first, why should I follow this plea bargain agreement? Okay, anything from Vince?
Judge, I think this is a situation where my client greatly regrets what he did. It's a situation that got out of control. And I think based on his background and age, it's one of those, we should have made much wiser decisions. He doesn't have a violent background. And I do know, and I think the court can tell from how he's answering questions, there's quite a bit of regret in this entire affair, Your Honor.
All right, so why did it come to this?
Your Honor, it was just a messed up situation that night. I wish I could have made a different decision. You know, my son was in the car with me. I was worried about his safety 100%. And a minute that hasn't gone by since this has happened that I wish I could have made a better decision that night.
Okay, I understand what you're saying, but I still don't understand how an argument on the road comes to a pulling of a weapon. I just don't understand that. And they're asking for a driver safety course. They're asking for a gun safety course. They're asking that you forfeit your Horseshoe Bay badge credentials. And they're saying that you flashed a badge and that you were no longer employed with them. So I'm just trying to figure out what conditions would be appropriate for you. This is why I asked these questions, because there's a lot listed.
Used the old time to diffuse the situation. I thought it would help. That was it. There was no other reason behind it.
Why did you still have the badge?
It was given to me by my chief of police at the time as a memento, because that was my first job there before I went to Border Patrol.
So where do you work now?
I've left law. I left Border Patrol in 2016. I went back to construction. I'm a home inspector for new homes. Till this happened, I was planning on going back to actually apply for ICE. That's null and void.
I mean, but here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
No, so Judge, he has a suppressor, and so his parents live near Kerrville.
Okay.
That's what the mother and father, they had gone out to her birthday celebration that night. He was going home with his son. And they have it's in a rural area, so they actually have kind of a setup where they do target practice. The suppressor has more to do with not making loud bangs. That's why he had, and it's legally owned. He's got the stamp for it. I have it in my file back, trial file. It's not illegally possessed. Otherwise, I guess the feds would be involved in this case, Your Honor. That's why I had the silencer. I can tell you that there was a perception on my client's part that the kid was tailgating. Then there was a brake check, which you can see from the statement and the police reports. And then the kid comes around really close, rolls down his window, honks at him, yells, starts cussing, and it kind of goes from there. It goes kind of south. I think my client thought he could handle the situation. He thought he would diffuse it with the badge. That didn't work. And then at the moment when this all happened, apparently the young man had a phone in his hand. This was at night, and he made a gesture kind of with his hand to the side, which at that moment in time, my client, who was already kind of freaked out, thought it was a gun. And this was an apparent danger case, Your Honor. Police didn't find a gun in the kid's car, but that's what we saw. We actually, in the subpoenas, dug up extraneous acts where kid had got in trouble at school for posting shots on social media with him with guns. And he's holding it the same way he was holding the phone. When he's talking to the police officers, he's holding it, he's pointing like this. So that's the gesture my client saw in that moment. He made a mistake. We've spent a lot of time on this. The state has spent a lot of time. They showed us a new witness who was the girlfriend of the young man in the car at the time that nobody had ever found. We'd always went, why weren't they looking for the girlfriend? We couldn't find her. We didn't know her name. Ms. Alban did a great job preparing for trial. And that's kind of why we're here today, Judge. I think both sides have kind of met in the middle. Again, my client doesn't have a violent background. It's just thank God that he didn't hit the kid. So that's why we're here.
Oh, is there something else?
Well, I mean, I'm not sure it's clear. The gun was in the car because of going out target practicing, but he had gone and met his family for dinner, and he was going home, and they were in the back seat of the car, in a bag. You know, it wasn't as if he routinely carries a gun.
He had been target practicing at his parents' house prior to dinner. He actually had a concealed carry permit, which he's since had to relinquish. The state revoked because of this.
Is there anything else?
No, Your Honor.
Anything else from the state?
Is happy with this resolution. I would, the court would like to hear now, I do have a restitution amount put on the judgment.
Yes.
It's $2,463.82.
I'm sorry,
Okay.
just 1 second. If you could repeat that.
$2,463.82.
So is there any disagreement on that restitution amount?
No, I think that was part of the discovery. We actually had the receipt from the repair shop, Your Honor.
And where will you have that restitution amount?
Judge, I think it's going to take a couple of months if the court would entertain that. He started this job about June, maybe, and so there's been some lag time. And I mean, he is the independent contractor, so lag time in taking the jobs and getting paid.
All right, just 1 second. Excuse me. Everybody on this side, y'all need to move because probation can't see and they can't hear what's going on. All right, so when do you think it will be? Oh, and state your excuse. When do you think he will have that?
If I had, I would say a minimum 2 months.
Yeah, minimum 60 days.
All right. And that's 60 days from today? All right, this is what the court is going to do. The court, and I'm going to tell you, I was considering sending you to jail as a condition, but the state is saying that the complainant is in agreement to this being your sentence. So you can thank the complainant for that. Because sometimes I feel as though people need to have a chance to be alone in their thoughts at the jail to consider everything that is what they've done. And it appears that you've taken that into consideration. And it appears that on this night, everything that could go wrong did go wrong. But don't brake check people. People don't like to be brake checked. That's just my experience from driving. All right, 5 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. And I'm sorry, what do? You said you're in construction?
Yes, we have new home inspections.
All right, he can do regular random UAs, or either you can do the patch. The patch costs more, but with the patch, it gives you more freedom because probation will put it on and probation will take it off. Patch costs more though. So you can either do regular random UAs or the patch. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 120 hours of community service restitution. I'm gonna require parenting classes. Once you complete that, the community service hours will be deemed satisfied. MRT, the anger management course, you're to forfeit the weapon, and you're to forfeit your Horseshoe Bay badge credentials. There's to be no firearm possession. There's to be restitution in the amount of $2,463.82 to Joseph Perez, and that's to be paid in full within 60 days. There's to be no contact with Joseph Perez. There's to be no employment with law enforcement or any type of security. There's to be field visits one time per month for 6 months. Are you here in Bear County?
Yes, ma'am.
All right. Probation, is there anything else? All right, and I'm sorry, there's a $1,500 fine that will be probated. Is there anything else that you need from the court?
Yeah, Judge, in regard to employment, if some of the jobs are out of county, I know some are in contiguous counties, but if they're further, does he just, can he get permission to do that if he shows probation where he's going?
Yes. Probation, he's allowed to work throughout Bear County and other counties, but you'll need to provide notification to probation that you're going to be working out of county. Working in county, that's fine. But if you're going out of county, you need to let them know. All right, is there anything else?
And I just, actually part of the plea bargain was actually to not only just waive, but to actually dismiss the set count two. I don't know if that was clear. You did do it, you waived it, but that is part of the inducement for the plea is that, and it was to be.
Oh, I've already said that it's been waived. It's on the record.
No, I understand that, but they, I'm just being hyper-technical.
No. I understand what you're saying, but I put on the record that
Yes.
it was waived and you all had no objections to it being waived.
Correct,
So
correct.
it will not come back.
Okay.
It's not allowed to come back.
There you go.
'Cause-
That's what I
All
want.
right,
All right,
thank you.
Sorry.
No problem.
All
Did you, and I'm sorry, there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, communication with probation is key. If there's an issue, you need to let them know about it. If you feel they're not addressing it, you can always come back and address it to court. But whatever you do not disappear on probation. That's not a good look. You understand? All right, good luck to you. Thank you.
Thank you, Your Honor.
You're welcome.
Okie dokie, my friends, that will do it for today. I hope you all had fun. I know I did. I'll say it again. It's just nice to be back. So much so, we'll do it again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. And apologies to channel members that the pre-show is probably going to be a little bit truncated for the next couple of weeks for obvious reasons. But I appreciate all of you. I do have one favor to ask for those of you who are still around. I'm often asked, how can you help the channel? The biggest thing you can do right now, if you have any kind of social media, Facebook, X, Instagram, whatever, share the channel, share videos that you like, do it often. That's one of the best things you can do right now. YouTube is going through a little bit of a funky phase. It's not just me, it's all creators. We're all seeing a large dip in our numbers. So not only here, but any creator that you like, if you want to support them, share the work that they do in other places, because the algorithm picks that up and it helps boost how often they're shown to others. So it's one of the best things you can do. But again, we'll see you tomorrow. Go have yourselves a great Wednesday, and take care. God bless.